Be allowed to bring it out in the conflict. Like,
Yeah, please, Your Lordship. Lordship, I recommended to IA for increment of parties in the petition. Regarding the road construction of the Nalbari Highway, the applicant is the contractor there, and the writ petitioners, in view of acquisition of land, have filed the writ petition hearing, and there is no stay order as such, but they are not allowing us to complete the construction. Only that part is left.
Your national highway?
Yes, madam. Yes, madam. Nalbari National Highway.
What do you want?
Alert on Monday. Deeply.
May I please, Your Lordship? Your Lordship, this series from item number 17 to 32, Your Lordship, part third, Your Lordship, I was supposed to file an affidavit, Your Lordship. But due to Your Lordship bereavement and I was out of station, Your Lordship, I could not file it. Your Lordships can accommodate it till 15th, Your Lordship.
Let us have it on then 20.
Lords,
File your affidavit
Lord.
by then.
Lords.
What is
Deeply,
Only a point involved
Lords.
is whether you have the jurisdiction.
Lords, that is the
Oh.
point.
It's a very short affidavit.
So far as one part is concerned, I will concede that I don't have the jurisdiction so far as declared fisheries is concerned. But while arguing, Mr. Bonik has shown one order, Your Lordship, whereby all water bodies were vested with the fisheries department.
That's 7-2.
Lords, on
7th
that
of May.
only I will file an affidavit, Your Lordship.
the interim orders being completed?
Mr. S. Pottaku, the Learned Counsel appearing on behalf of the missing autonomous council, submits that on account of these personal difficulties, the affidavit which was directed to be filed could not be filed. He submits that he would file the missing autonomous council would file the affidavit before 15th of August 2020. Into account that above this court fixes the matter on 28 2024. Same orders passed earlier shall continue.
Deeply obliged.
please, Your Lordship. I beg to make a mention for listing of an matter for motion tomorrow, Your Lordship. We have urgency in the matter recovery proceedings. Highly
What? Today or tomorrow?
tomorrow, yeah. Like,
Well, what did you find out?
regarding the source, I have found something, Milord.
Which?
I have underlined that portion, paragraph 4.
Sir, what is this?
Milord. This is, yes, similar situation is here, Milord. This is, Milord, finance taxation department, Milord. This is this rule, Milord. And if your lordship come to rule 2I. 2I.
2I.
Yes. It speaks about ministerial staff, but their service condition is not given.
Bill Convent. It shall apply to whom?
my lord.
When you come to rule 3, the service shall consist of the following class and cadres.
Yes,
A, it shall include the cadres of so and so, so and so, so and so, so and so.
Ah.
2, it shall include the cadre of so and so. But 2 it is. The service may also include any post equivalent to a post in any cadres mentioned in subrule I means what? I think it should be subrule 1.
my lord, it is A1, I think, additional commissioner taxes.
Hmm?
Additional commissioner taxes.
Understood? So, there is no mention of subrule A1, but only one.
Only one.
Any cadre or post laid down by the government to be included to a cadre of the service. So, under such circumstances, unless it is being laid down, how do you bring the ministerial stuff here? It is not in the cadre.
But I'm submit, my lord. This rule speaks about ministerial staff,
Understood?
but their service conditions are not given.
Obviously,
So
why
under-
it is, no, why they are not giving in view of 3? Unless you say that 2A, rule 3 2A, the word, the number 2 is missing.
two is missing.
Huh?
Yes, two is missing. But if we go through entire rule, my lord, it has not prescribed anything about the service condition. of-
Obviously, that is why it is not being done. Because they should have, but they are not doing it. They could have, but for that to do it, they ought to have brought 2A, rule 3 2B. Any cadre or post laid by the government to be included in the cadre of the service. They did not bring anybody else. So here, therefore, the promotion is only limited to the last of it is the inspector.
Yes, that is why. Regarding ministerial staff, nothing is given.
No, therefore, they have not included it in the cadre. Unless they brought it under section rule 3 2B. They should have brought it under 3 2B, which they have not brought it. They must have forgotten. But the judgment which you are referring to, do not quarrel with that proposition. But then also, to be an executive order, it has to be in consonance with Article 166(2).
Issues by governor.
No, I'm not on that. The judgment where you are saying about the executive order, be an executive order, it has to be in consonance with Article 166(2). There are many judgments on that. So therefore, to say that at best to be a instrument of the government has to be on the basis of a power being conferred upon the Commissioner of Taxes. Therefore, that principle would not apply. However, the court is with you as regards a review is required, taking into account that they themselves say that these rules do not apply. Now, if these things do not apply, only the spirit, can this court bring in section rule 66 of the Assam Ministerial Rule? Which I think this court could not have done it. Therefore, the judgment is required to be reviewed. I mean, with that, not on the basis of anything else, because that is their own stand itself. So therefore, 66, on the basis of that, the judgment could not have been passed. Now, the question, therefore, on the last occasion was, as to the moment I review it, what is the next step? That is the reason why I didn't deliver the judgment on that day.
Probably, my lord, order 47, rule 8 will help, my lord. Let's see rule 8. When an application for review is granted, a note thereof shall be made in the register, and the court may at once rehear the case or make such order in regard to rehearing as it thinks fit. So it can be heard at once.
By this court. And I will take it that that post is lying vacant.
Yes, that of course, my lord.
That is your submission. And accordingly, direct, while setting aside, confirming the setting
Yes,
aside
that
of
part
them,
will be-
his appointment, because his case was not, he is senior to him. Direct him to do so as per the extent laws. Is the only way, because I can't give you a promotion. And I can only give you a order for consideration in terms with them. That's the only order, isn't it? You dictate. Review petition, huh? Hey, I'll work on the review, so. Review petition 28 and 2023 and review petition 128/2020. I've heard Mr. S. Sahu, the learned counsel, appearing on behalf of the review petitioner. In review petition number 128/2023, as well as Mr. M.P. Sharma, the learned counsel, representing the review petitioner in review petition number 28/2023.
I'm the respondent number 4 in his petition, and
I know that. I've also heard Mr. B. Gugoi, the learned standing counsel of the Finance and Taxation Department of the Government of Assam. Both these review petitions have been filed challenging, seeking review of the judgment and order dated 4/1/2023 passed in WPC number 2121/2018. For the sake of convenience, this court would refer to the parties herein in the same status as they stood in the writ proceedings. The review petitioner in review petition number 128/2023 is the petitioner in WPC number 2121/2018, and the review petitioner in the review petition number 28/2023 is the respondent number 4 in the said writ petition. The ground on which the review petition has been filed is that an error has been committed. An error apparent on the face of the record have been committed by this court by dismissing the writ petition. Now, by partly dismissing the writ petition, and partly by passing appropriate directions, directing reversion of the respondent number 4 to his original post. Five over there, 5 to his original post. The error which have been submitted to have been committed by this court, which is apparent on the face of the record, is that this court had applied the amended Rule 66 of the Assam Ministerial District Establishment Service Rules 1967, for short, the Rules of 1967, which, as per both the review counsels for the review petitioners, could not have been applied so in view of the office memorandum dated 6/4/1999, whereby only the unamended Assam Ministerial District Establishment Service Rules 1967 was incorporated to the service conditions. The counsels appearing on behalf of both the review petitioners duly submitted that, taking into account that only the unamended Rule 66 of the Rules of 1967 was incorporated, the principles of legislation by incorporation shall apply. And irrespective of an amendment being made to Rule 66 by in the rules of 1967, unless and until the same is again reincorporated to the circular, by any office memorandum or circular, the service conditions has to be adjudged on the basis of the office memorandum dated 6/4/1999. In that regard, the learned counsel appearing on behalf of the review petitioners have relied upon the judgments of the Supreme Court in the case of, where are those? You gave these two judgments, na? Got it, got it. In the case of Mohan Chaudhary versus the Chief Commissioner, Union Territory of Tripura, reported in AIR 1964 SC 173, as well as the judgment in the case of the state of MP versus MV Narasimham, NIMHAM, reported in 1975 SC 1835. It is seen that both the judgments in that regard, the learned counsels referred to paragraph 11 in the case of the judgment rendered in the case of the judgment rendered in Mohan Chaudhary Supra, and paragraph number 16 in the case of MV Narasimham Supra. The learned counsels appearing on behalf of the petitioners further submitted, review petitioners further submitted that the basis on which both the judgments have been delivered is in terms with Section 8 of the General Clauses Act 1897, wherein the principle of legislation by incorporation has been statutorily mandated. In addition to that, the learned counsels appearing on behalf of the review petitioners further submitted that a perusal of the stand which have been taken by the respondent authorities in their affidavits also clearly show that they have not adopted the rules of 1967 and have only stated that the principle of the rules of 1967 is being adopted, is to be followed. It is therefore the submission of the learned counsel appearing on behalf of the review petitioners that if only the principle is to be followed and the rules of 1967 have not been adopted, this court had An error apparent on the face of the record had crept in the judgment sought to be reviewed. On the basis that this court applied the amended Rule 66 of the rules of 1967. It has been submitted that if such a submitted that anything more? You? To the seats, per contra, Mr. B. Gogoi, the learned counsel appearing on behalf of the Finance and Taxation Department of the Government of Assam, submitted that a perusal of the communication dated 6/4/1999 very deep.
Page 43 on the review petition number 28. Page 43.
Yes. Would show that in view of various requests being made seeking clarification to the commissioner of taxes, the office memorandum dated 6/4/1999 was issued. In view of there being no service rules for the establishment of the subordinate offices under the commissionerate post. It was also mentioned in the said office memorandum that as the rules of 1967 is generally followed by the subordinate officers for guidelines, subordinate officers, comma. The said rules of 1967 be followed wherever felt necessary. The learned counsel further submitted that at that relevant point of time, in terms with the unamended Rule 66 of the rules of 1967, for the purpose of promotion to the post of LD assistant, the required qualification was HSLC or equivalent examination and have rendered at least 7 years of continuous service on the first day of the year in which the selection is made. The learned counsel appearing on behalf of the respondent state therefore submitted that in view of the amendment being made to Rule 66 in the year 2015, the respondent authorities now the qualification required would be in terms with the amended Rule 66 of the rules of 1967. Isn't that, Mr. Gogoi? In addition to that, the learned counsel appearing on behalf of the Finance and Taxation Department further submitted that the respondent number 5 in the writ petition is admittedly junior to the writ petitioner. And as such, even assuming the educational qualification is SSLC pass, then also the review petition so filed by the respondent number 5 has no legs to stand in as much as the respondent number 5 cannot supersede the petitioner, taking into account that the selection, the criteria for the selection is seniority cum merit. Under such circumstances, the learned counsel therefore submitted that a review application number 28/2023 ought to be dismissed on that account alone. It is also submitted that there was a confusion amongst the respondent authorities as to whether the Rule 66, whether the old unamended Rule 66 or the Rule 66 would apply. In view of various communications issued by certain officials, but in view of the judgment passed by this court, which is sought to be reviewed, the respondent authorities have taken a decision to apply the amended Rule 66 of the rules of 1967. Isn't that?
One more thing, Madam, regarding as to why.
Is this right?
Yes, yes. But this part.
Now, in view of my decision, you have taken now that
Yes, we have
amended
stated in
Rule
my
66 will apply. Then,
We have stated that it has been clarified by the honorable court now, so we'll follow that only. Well, prior to that, my lord, so far as the Nilotho Deka, who is the private respondent, he was given promotion, though he was junior to the petitioner. The ground was that, my lord, the petitioner is working as a, my lord, Sokidar. Whereas, so far as the private respondent is concerned, he is working as peon. So considering that part, since my lord, he is working out of the office as a Sokidar, so he was not given the promotion to the post of junior assistant. That was the ground, my lord, given in the affidavit, additionally. Though senior, my lord, he was not given
but
because.
that has no relevance.
Yes, that we have stated, there is nothing in the rule to, my lord. differentiate
No,
the
you
two
don't
posts. They are
differentiate.
grade 4 posts, otherwise.
I've heard the learned counsels appearing on behalf of the parties and have given anxious consideration to their respective submissions. Let this court first take up the point urged by the learned counsels appearing on behalf of the review petitioners as regards the applicability of the principle of the doctrine, applicability of the doctrine of the applicability of the principles of legislation by incorporation For doing so, this court finds it relevant to take note of Section 8 of the General Clauses Act 1897. Court go on. The said provision is reproduced hereunder. A perusal of the above quoted provision shows that when the Act of 1897 or any central act or regulation made after the commencement of the Act of 1897 repeals and reenacts with or without modification any provision of the former enactment, then the reference in any other enactment or in any instrument to the provision so repealed shall, unless a different intention appears, be construed as reference to the provisions so reenacted. The Supreme Court, in the case of M.V. Narasimham, Tupra, observed that when a subsequent act incorporates provisions of a previous act, then the borrowed provisions becomes an integral and independent part of the subsequent act and are totally unaffected by any repeal or amendment in the previous act. It was also observed that this principle, however, shall not apply in the following cases. A, where the subsequent act and the previous act are supplemental to each other. B, where the two acts are in perimeteria. C, where the amendment in the previous act, comma, if not imported into the subsequent act also, would render the subsequent act wholly unworkable and ineffectual. And D, where the amendment of the previous act, comma, either expressly or by necessary intendment, applies the said provisions to the subsequent act. In a subsequent judgment by the Supreme Court in the case of State of Uttarakhand versus Mohan Singh and others, reported in 2012 13 SCC 281, the Supreme Court had very carefully drawn the distinction between a referential legislation and a legislation by incorporation. This aspect of the matter is very relevant, taking into account the submissions so made by the learned counsel appearing on behalf of the review petitioners. As per the Supreme Court in the sage judgment in Mohan Singh Supra, a subsequent legislation often makes a reference to an earlier legislation so as to make the provisions of the earlier legislation applicable to matters covered by the later legislation. Such a subsequent legislation may either be a referential legislation, which merely contains a reference to or the citation of the provision of the earlier statutes, or a legislation by incorporation whereunder the provisions of the earlier legislation to which reference is made are incorporated into the later legislation by reference. The Supreme Court in Mohan Singh duly relied upon the judgment of the Supreme Court in the case of M.V. Narasimham Supra, and thereupon observed that a clear distinction has to be drawn between a mere reference or a citation of one statute into another and incorporation. In case of a mere reference of the citation, a modification, repeal, or reenactment of the statute that is referred will also have the effect for the statute in which it is referred. But in the later case, any change in the incorporated statute by way of an amendment or a repeal has no repercussions on the incorporating statute. In the same judgment, the Supreme Court further, taking note of Section 8(1) of the Act of 1897, observed that where there is a mere reference to or a citation of one enactment in another without incorporation, Section 8(1) applies, and the repeal and reenactment of the provision referred to or cited has the effect set out in that section, and the reference to the provision repealed is required to be construed as reference to the provision as reenacted. It was also observed that where a provision of one statute is incorporated in another, the repeal or amendment of the former does not affect the later. The effect of incorporation is as if the provision incorporated were written out in the incorporating statute and were part of it. Explaining the term legislation by incorporation, the Supreme Court observed that this principle is a common legislative device employed by the legislature, where the legislature, for convenience of drafting, incorporates provisions from any existing statute by reference to that statute instead of setting out for itself at length the provision which it desires to adopt. Once the incorporation is made, the provision incorporated becomes an integral part of the statute in which it is transposed, and thereafter there is no need to refer to the statute from which the incorporation is made, and any subsequent amendment made in it has no effect on the incorporating of the statute. In the backdrop of the above, let this court take note of as to whether the judgment, whether the principle of, whether the doctrine, the principles of legislation by incorporation would at all apply to the instant proceedings, at all apply, insofar as the office memorandum dated 6/4/1999 no doubt that the office memorandum is not a statute. However, the learned counsel appearing on behalf of the petitioner, a review petitioner submits that an instrument would also would come within the ambit of legislation by incorporation in view of the fact that in absence of a statutory rule, an executive order would hold an executive order can be made to fill up the lacuna in the statutory rules. The learned counsel appearing on behalf of the review petitioners therefore referred to the Constitution judgment in the case of Mohan Chaudhary, Supra, as well as the judgment of another judgment of the Supreme Court in the case of Union of India versus H.R. Patankar, Patankar, reported in 1984, AIR 1984 SC 1587. This court have duly perused the judgment of the Constitution Bench in the case of Mohan Chaudhary, wherein the reference to the instrument wherein it was held that a presidential order would come within the meaning of the term instrument as employed in Section 8 of the Act of 1897. It is also being submitted, and of course, this court have also perused the judgment of the Supreme Court in the case of H.R. Patankar, Supra, wherein the Supreme Court had duly observed that in absence of the statutory rules, or where the statutory rules are silent. It is competent to the government by an executive order to make appropriate seniority rules or fill in the lacuna in the statutory rules by making an appropriate seniority rule in regard to the subject in which the statutory rule is silent. But the question arises as to whether but the question arises in the instant case as to whether a circular, as to what is a executive order. An executive order, in terms with the Constitution, would be an order passed under Article 166 of the Constitution. Full Constitution. Would be an order. Enter, what is that provision? An executive order is an order coming within the ambit of Article 77 bracket 2 of the Constitution, insofar as the government of India is concerned. And insofar as the state, it would be Article 166(2) of the Constitution. Such executive orders has to be in the case of the government of India, has to be in the name of the president. And in the case of the state, has to be in the name of the governor. In the backdrop of the above, this court would like to take the office memorandum dated 6/4/1999. The said office memorandum under no circumstances can be said to come within the ambit of a legislation or even an instrument. For the purpose of applying the principles of legislation by incorporation. The said office memorandum has been issued by the Commissioner of Taxes making certain clarifications in view of the fact that there are no statutory rules. Taking into account that the said office memorandum is dated 6/4/1999, the power of the Commissioner of Taxes has to be therefore taken in the context of Section 3 of the Assam General Sales Tax Act 1993 as an officer appointed as an officer appointed to carry out the purposes of the Act of the Assam purpose of the Assam General Sales Tax Act 1993. There is nothing shown, nothing brought before this court to show that the said office memorandum dated 6/4/1999 was issued upon being duly authorized in terms with Article 166(2) of the Constitution. Therefore, in the opinion of this court, the principle of legislation by incorporation cannot be imported as regards the office memorandum dated 6/4/1999. This court, in the backdrop of above, let this court now take note of the second submission so made by the learned counsels appearing on behalf of the review petitioners, to the effect that it is the stand of the respondent state itself that they have not adopted the rules of 1967. And as such, Rule 66 of the Rules of 1967 could not, Rule 66, and the amended Rule 66 of the Rules of 1967 could not have been made the basis on which the writ petition could have been dismissed. Could not have been made the basis on which the judgment sought to be reviewed have been passed. This will take care of both. Because if I say he is a dismiss also, he is the one who wants the dismissal. Nah? This court have duly perused the affidavits which have been filed by the Finance Department the various affidavits filed by the Finance Department in the instant proceedings. The stand taken by the Finance and Taxation Department, the stand so taken by the said department is not clear as to whether they have adopted the rules of 1967. In fact, their affidavit categorically states that the department was under a state of confusion as to whether to apply the rules 66, the unamended rule 66 or the amended one. This court is of the opinion that if that is the stand of the department and amended was in a state of confusion as to whether the rule 66, the amended or the unamended rule 66 should be applied. It is also the stand of the respondent state, of the respondent department, that it is on the basis of the judgments which have been sought to be reviewed, a clarity has sought to be reviewed, wherein it was stated that the amended rule 66 have been applied, is to be applied. The department is now applying rule 66, the amended rule 6. Taking into account the stand which taken by the respondent department, it is the opinion of this court that the rule 66, the amended rule 66, could not have been made the basis for disposing of the writ petition. Inasmuch as the respondent department is still is unaware inasmuch as the stand of the respondent department lacks clarity as to whether the rules of 1967 have been adopted or not even. It is the further opinion of this court that applying rule 66, the amended rule 66, in passing the impugned judgment sought to be reviewed, this court stepped into the shoes of the executive which could not have been done. And as such, an error apparent on the face of the record had crept in passing the impugned judgment and order, thereby applying the amended Rule 66 to the rules of 1967. Accordingly, this court recalls the order, the judgment and order dated 4/1/2023, reviews the order dated 4/1/2023, passed in so and so, and the writ petition is restored back to the file. Well, now come to the writ petition. Let me come back in 5 minutes. At last, the end of the matter. Huh? Not
Yes, sir.
too much of. Repetition. Heard Mr. S. Sahu, the learned counsel appearing on behalf of the petitioner. Mr. E. Gogoi, the learned standing counsel of the Finance and Taxation Department of the Government of Assam. And Mr. M. P. Sharma, the learned counsel appearing on behalf of the respondent. This court, vide a judgment and order dated in review petition number 28/2023 and review petition number 2128/2023 had reviewed the judgment and order dated 4/1/2023 passed in WPC number in the instant writ petition. The effect of the review so made, effect of reviewing the judgment and order dated 4/1/2023 in the instant proceedings has led to the restoring of the instant writ petition and recalling of the said order, judgment and order. Though under section 141 of the Code of Civil Procedure 1908, the principles, the provisions of the Code of Civil Procedure is not applicable to a proceedings under Article 2 to 6 of the Constitution. But however, in view of the well-settled principles, the spirit of the said provision, said code is applied while disposing of or while taking into account a review proceedings. Under such circumstances, this court, taking into account the provisions of Order 47, Rule 8 of the Code of Civil Procedure, is required to rehear the instant writ petition or pass such other orders as may deem fit. It has been submitted by the learned counsel appearing on behalf of the petitioner that if the instant writ petition is not taken up for disposal, forthwith, it would result in perpetuation of an illegality whereby the respondent number 5 was illegally appointed to the post of judicial assistant. Mr. B. Gogoi, the learned counsel appearing on behalf of the respondent department, also submits that in view of the setting aside of the appointment of the respondent number 5 by the judgment and order dated 4/1/2023, the post is still lying vacant. And an early disposal of the instant writ petition would be in the interest of exigency of service. It is under such circumstances this court, therefore, takes up the matter for hearing. The petitioner in the instant case was appointed to the post of Chokidar, grade 4, in the office of the Superintendent of Taxes, Guwahati. His appointment was regularized by an order dated 24/2/1995. On the other hand, the respondent number 5 was appointed as a on the other hand, the respondent number 5 joined the respondent department only on 23/1998. However, both the petitioner as well as the respondent number 5 was confirmed on 3/11/2003. At this stage, this court finds it very pertinent to take note of an affidavit filed in the review proceedings by the respondent number 3 to the Joint Commissioner of Taxes, Assam. Paragraph 6 of the said affidavit is reproduced herein under. Running page 90 আছে in number 28 running page 90, affidavit dated 21/11/2023. The above paragraph is quoted for the purpose of taking into account the admitted stand of the respondent department that the petitioner is senior to the respondent number 5, taking into account the admitted stand of the respondent department, which are, number one, that the petitioner is senior to the respondent number 5 by 3 years, 5 months, 19 days. Number two, though the date of confirmation of both the petitioner and the respondent number 7 are on 3/11/2003, but as the petitioner had joined the department earlier, the petitioner is senior to the respondent number 5. And this aspect is supported by the records. Number 3. The appointment, the consideration of the respondent number 5 was made by ignoring the case of the petitioner in view of an order being passed by this court in WPC number 5831/2016, wherein this court had directed to consider the case of the respondent number 5 for his promotion to the post of the LDA. Establishment Rules, Service Rules 1967, for short, the Act Rules of 1967. ওটা যদি লিখিছো ঠিক করে দিও, হ্যাঁ? Was directed to be generally followed wherever necessary by the Office Memorandum dated 6/4/1999. The Office Memorandum further stipulates that the criteria to be followed is seniority cum merit, and the qualification are that a person, that an employee had passed HSLC or equivalent examination and have rendered at least 7 years of continuous service on the first day of the year on which the selection is made. These criteria and qualification apparently seems to be on the basis of the unamended Rule 66 of the Rules of 1967. However, Rule 66 of the Rules of 1967 was amended with effect from 15/10/2015. In terms with Rule 6, bracket 6, bracket B, the criteria remains the same. That is seniority cum merit. But the qualification was made that the employee have passed degree examination in any discipline from a recognized university or an examination declared equivalent thereto. The requirement of having at least 7 years of continuous service in the district establishment remains the same. As per you, the old rules was followed.
Final?
As per you, the old rules was followed.
Yes, when so far as this
Election. It is, this court had put a specific query upon Mr. B. Gogoi, the learned standing counsel of the respondent department, as to under what rules as to whether the pre-amended Rule 66 or the amended Rule 66 of the Rules of 1967 were followed for the purpose of considering the case of the petitioner to the post of, considering the case of the petitioner and the respondent number 5 to the post of junior assistant judicial.
This
junior-
particular circular dated 6/4/99, that was considered. not the rule, madam.
That
because
is
it-
your
it-
answer. That is my query.
Lordship.
Post of
Junior assistant.
junior assistant. The Learned Standing Council submitted that the qualifications so mentioned in the office memorandum dated 6 qualification and criteria so mentioned in the office memorandum dated 6/4/99 was followed. Taking into account the said stand, it is apparent that as regards the educational qualification, educational qualification, both the petitioner as well as the respondent number 5 were duly qualified. In addition to that, both the petitioner as well as the respondent number 5 had 7 years of had 7 years, had rendered 7 years of continuous service. On the first day of the year in which the selection is made. The question therefore arises as to whether the criteria for the selection to the post of the criteria, which was seniority cum merit, has been properly applied. Of how is that relevant? Your compassionate appointment. If any out order is there in respect to filling up of any vacancy of grade 3, or if any case of appointment on compassionate appointment is pending, those matters should be taken into consideration before filling up any post of grade 3 by promotion from so and so. Then, huh? How does this have any relevance? So, should be taken into consideration before filling up any post of grade 3 by promotion from grade 4 employees. So if you mean to say there was a court's order in 5683 and therefore your case has to be considered. Absolutely. No, don't make that submission. It becomes ridiculous. That can be a ground of review again. Arises as to whether the criteria of seniority cum merit was duly applied. It is a well-settled principle of law. It is well settled that while construing the criteria seniority cum merit, seniority is given a precedence. And merit would only come into the picture when the seniority is equivalent. Isn't that?
Yes.
I'm a bench one man judge, so that is why I'm saying that. Under such circumstances, taking into account the admitted stand of the respondent department in the affidavit, in paragraph 6 of the affidavit, which have been quoted herein above, the petitioner herein was senior to the respondent number 5. By 3 years, 5 months, 19 days. Under such circumstances, in that view of the matter, the selection of the respondent number 5, thereby ignoring the case of the petitioner, is clearly violative of Article 14 and 16 of the Constitution, apart from being in violation to the standards adopted in terms with the office memorandum dated 6/4/1999. Under such circumstances, this court sets aside the promotion of the respondent number 5 made by memo number 4266 dated 1/2/2018. The next question arises as to whether this court should pass appropriate directions to promote the petitioner to the post of junior assistant. That too with effect from the date of promotion of the respondent number 5. This court is of the opinion that such a direction would not be in the exigency of service. Instead, this court is of the opinion a direction to consider the case of both the petitioner and the respondent number 5 in accordance with the extant laws would be in the interest of justice. Accordingly, this court, therefore, while setting aside the appointment of the respondent number 5 to the post of junior assistant by memo number 4266 dated 1/2/2018, directs the respondent authorities to conduct appropriate selection process to the vacant posts which had come into existence in view of the setting aside of the order of appointment of the respondent number 5, and the same be done in terms with the and the same be carried out as per the applicable laws, applicable rules, oblique orders, etc., holding the field. Full stop. Next. This court makes it clear that this court, for the sake of clarity, observes that this court have not made any comment as to whether the unamended Rule 66 or the amended Rule 66 of the rules of 1967 shall apply. It is left to the best wisdom of the respondent department, who shall do so in the interest of the administration.
Well, the order
Yes.
interfered is a order of promotion, not final appointment.
As well as
No, the order interfered is a order of promotion, not appointment. That promotion word should be there instead of appointment.
promotion. Huh? Which one? In view of that judgment for considering you. Where? How do you apply that? No, tell me, how do I apply 41.5? It is already there because he said it is already there. In paragraph number 6, which I have quoted, they categorically say that we have given the precedence about you because of the order passed in 5683. That is the case you want. That becomes a good case for you to appeal. No more review. Then enough. It is already there. That is quoted. Not only that, he also submitted. I have quoted his submission.
Like, well, the order was to consider, not to give promotion.
It is for consideration. And for consideration, you cannot say that. Not befitting submission.
Apply.
Your lordship has said, your lordship is a page 1 judge, but we find all rounder.
Huh?
We found all rounder.
What?
Your lordship is a all rounder.
Why? No, civil bench 1.
One for admission.
Yes, what is this, Mr. Ali?
Lordship, it is a very simple matter. Matter is your lordship. It is a Idga, your lordship, this full Idga, Maidan, your lordship.
Hmm.
And that is actually in such name, your lordship, since the year 1923, in the days of British. It is being named as Idga, this full Idga, your lordship. Now, in the passage of time, your lordship, some groups of persons, your lordship, they have influenced the authorities, your lordship. Now, this Idga has been there is a suffix and sometimes there is prefix also, your lordship. By adding Sitraban Bakori, your lordship.
Huh?
Sitraban Bakori, your lordship, along with this Idga. This Sitraban Bakori, your lordship, it is a different field, your lordship. That is of the Mahakama Parishad, your lordship, that is measuring about.
Sometime in 675, the word
Now-
Chitrabon Bakori. What is that?
Sitraban Bakori, your lordship. It is the creation of the respondent, your lordship. It is not creation of the petitioner, your lord. Now that words actually this Sitraban Bakori has been either sometimes it is prefix or sometimes suffix, your lordship, in the name of the Idga Maidan, your lordship. So our contention is, your lordship, since it is a
That
Idga
rectification was made.
lordship,
That rectification was made. Then
so Thereafter, again, your Honor, it is being used, your lordship.
By the deputy commissioner.
So, your lordship, may I take your lordship to document number 2, your lordship? This annexure 2, your lordship.
So what do you want?
So, my simple prayer is, your lordship, that before the.
Should not be issued
and after
directly
the
to
Idgah, my
refer
lord,
the
your
name Idgar field without tagging or adding the word Chitraban Bakuri. What
So-
is Chitraban Bakuri?
lordship. That Chitraban Bakuri, your lordship, it will create problem. That is the Orthodox group there, your lordship. They are trying to add this word, your lordship, so that they can, your lordship, use the Idgah, your lordship, for their own interest, your lordship. And
No, what is the meaning of that?
Chitraban Bakuri.
Oh.
Chitraban, your lordship, it is a small plot of land on the eastern side of the Idgah.
No, that I know. I'm saying, what do you mean by Chitraban Bakuri?
So it is a name given to a plot of land, your lordship. It is a name given to a
No,
small.
that name has to have a meaning.
Chitraban means beautiful.
Beautiful.
place, your
And
lordship.
what is Bakuri?
Bakuri means, your lordship, this courtyard. Bakuri means courtyard
So
or
it's a beautiful yard. So you want the word used as beautiful yard. We'll put it in English if you don't line the ass me.
so that Bakuri, your
You
lordship,
can
that-
go ahead, Mr. Madam, you can go ahead, put it by in English, beautiful yard.
I'm reminded of the bard's famous quip in Romeo and Juliet. A rose by any other name would smell just as sweet.
A rose is always a rose in whatever name you say. Always a beautiful yard.
beautiful, your lordship. That is a different field, your lordship. Small field that is of land measuring 2 kotha. That is a Mahakama Porisad's land, your lordship. And that is on the eastern.
Now you want that this Chitraman Bakuri should be removed and put Idgar field.
No, that should not be used, your
So
lordship.
you say the name Idgar field without tagging or adding the name Chitraban Bakuri either.
Lordship.
Why are you using the Chitraban Bakuri? They are using.
That Malad has been,
And what is the Tezpur Municipal Board doing?
that has not been assailed. And in that PIL, Malad, the final judgment of this honorable court.
Oh, and what is Tezpur Municipal Board doing? You are Tezpur?
I'm Tejpur.
That has not been
Why?
assailed.
What is your thing?
I am appearing for the impleaded respondent, my lord. This field was all along, my lord, Chitraban Bakuri. It was allowed to the Mohammedan
Ishadi
community
for
of Tejpur
Chitraban.
for, my lord, reading the Eid prayers on 2 days.
Finding Malad, that has not been assailed. Called Chitraban Bakuri, which is now commonly known as Idgah.
My lord, in the read petition at page number 72, your lordship will find the judgment is there, my lord.
Page 75, Malad, last paragraph. It is that the field was initially
That I've seen it. Report has been filed by objection against the above and so and so. The direct respondent to use the landfill only for Eid prayers and immediately remove both the sheds which have been raised by it without any permission from the also direct not to prevent the public from using the field for morning work. We make it clear that if the respondent number 3 on its own fails to comply with our order, the district of directions are complied with in public. Just and after the unauthorized constructions, at liberty to apply as per law for making construction. Who is respond number 3?
them.
In the PIL, my lord, respondent number 3 was the district authority, my lord.
No. It mainly stated that out of the
Here-
two
here
states
the-
referred to the above, one is Urjua Khana,
In the PIL, my lord,
Which
the
year?
respondent number 3 was,
not them,
yes, the Idgah.
they were.
Yes, my lord. This petitioner.
No, this Chitraban Bakuri was not the issue there.
Lordship, that was the PI, your lordship, that we constructed some Ojukhana, your lordship. That Ojukhana, your lordship, they raised objection, this group, your lordship. This added,
Now tell me whether this land has been allotted to you.
yes, reserved, your lordship. Reserved for the Idda, your lordship.
Where is that? Show me.
Annexure to your lordship will come. At page 22, your lordship.
As per the order passed pursuant to the
As
basis
per the
of
order
application by here the
Pursuant
certified
and on the basis of the
copy of
application
the
number so and so.
land measuring so and
The
so
certified copy of Sita Dimension Moja
reserved for
found is issued, land measuring 3 biga 4 kata 11 lessons covered by table so and so.
what is this preserved?
As per the order, as
What do
per
you mean by preserved?
the order of back number so and so is preserved for Idga.
What is preserved? Very difficult in your matter
Lordship,
to understand the various names. What is preserved?
Idgahar babe
I
rokha.
have heard in land they are saying reserved. What is preserved? What do you mean by preserved?
Your lordship is correct,
Is it-
your lordship.
Is it reserved or preserved?
Reserved.
Reserved. If it is reserved, does it mean it to be an allotment?
So whether it is allotment or
They may keep it. Oh, we keep this for Idgar. They may keep it, but does it mean that it is a land?
that your lordship will come to the annexure 11, your lordship. That will finish the matter.
Page
Praise your lordship. Fifty-nine, huh?
11.
59, your lordship. Office of the Deputy Commissioner, Dorong Tesport, notice. To an ordinance so and so date, the government of Assam constituted a committee with the following members. Sri SP Hazarika as president to look into the objection raised with regard to the using of Tesport Disga field and to forward the suggestions for solving the matter. Members of the committee so and so. Now, as per the suggestions of the said committee, the government of Assam has taken some decisions regarding utilization of the Idga field. As mentioned, the field is recognized as Idga and it shows in the revenue records as such, subject to the following conditions. And the field can be used as a playground for neighboring children and the students of the school educational institutions. The field will remain open for audience of Tespur Rogali Bihu Sanmilan, but the stage for performance of the Bihu dance songs shall remain outside the periphery of the field. The stage of performance for Bihu dance songs, etc., will be set up on the adjacent vacant space of the Mahakama Parisad. An area of land measuring 14 to 20 feet will be kept for the purpose. This Mahakama Parisad land, that is the Sitraban Bakori, your lordship, they have given the name. Any kind of idols or pictures of idols, etc., cannot be established or placed or drawn on the permanent gate of the Idgah field during the Bihu celebration. Abstain from displaying, hanging any kind of picture, idols, drawings at the gates of the field, which may hurt the religious sentiment of the Muslim. If the Bihu Sammelan desires, it may display pictures, idols, etc. on a temporary erected gate outside the field. That is the Idgah field. The Pakka boundary wall of the field, which was constructed with due permission of the government, will remain. That Pakka wall actually the Idgah committee constructed, your lordship, will remain in place. But during Bihu days, the main gate of this said field should remain open for entry and exit of the audience and viewers. Deputy Commissioner shall take necessary steps in this regard. After celebration of Bihu functions, the Bihu committee would reinstate the field which earlier stayed by filling potholes, cleaning the field and leveling the ditches, etc. The above provisions have been adopted permanently. The government hope that such arrangements shall settle the dispute with regard to the use of Idgah field and maintain the harmony between the two communities. So, Your Lordship, from this settlement, Your Lordship, at the initiative of the Deputy Commissioner Dorong, so the field is recognized as Idgah. So this Tezpur Idgah, Your Lordship, after and before this Idgah, Your Lordship, there should not be any prefix or suffix, Your Lordship. Your Lordship, annexation 9, Your Lordship, it will throw light upon it, annexation 9. Annexation 9 at page 55.
Mr. Ali, if you see, I've looked into what is your case now. Kindly come to page 79. Your
79.
case is this, page 79. In the permission, they have used the word Chitraban Bakuri. And you have objected by filing a representation. Did? Now, the reference made in the permission is this. Seen and peruse the petition submitted by so-and-so seeking permission for Naya at Chitraman Bakuri. Now, that person, that committee, do not want to mention it as a Idgar. But the Deputy Commissioner does not say that. That is his application where he says that Chitravan Bakuri. Is what is being referred. If you see the order passed by the division bench,
Your Lordship,
it is categorically clear that the land is only reserved for doing Eid prayers. As well as it is a government cast land and it is under the custody of the Deputy Commissioner. The Deputy Commissioner shall use it for other purposes and you were obstructing by putting a gate, which the PIL was filed for that. That's it.
Lordship, PIL was filed, Your Lordship, without permission of the authority, municipality, Your Lordship, or guardian.
Did you get any permission to put a gate?
Thereafter, we applied for, we have been given, Your Lordship, we have constructed the.
Then you were obstructing the people from using it. You can't use stop
No,
it.
no, no, we are not obstruction, we will
Mr.
not obstruct.
No. This type of repetitions is not.
No, this election 11, Your Lordship.
No,
it
this is
will
a
clear.
case for
Everybody
dismissing.
has right, Your Lordship.
You want to go to prove yourself that
No.
it is a Idgar field, go and prove it in the civil court.
Lordship,
Nothing doing.
So far,
No. This is
we
not
are
the case.
actually concerned with the name, Your Lordship.
Now, that is
So
what.
our name is concerned, Your Lordship. we are
No,
not-
nothing. Nothing that somebody has said in an application for that a writ does not arise.
Lordship, Your Lordship will find in the 79 annexure 50, Your Lordship, rate.
That is what I am saying.
Your
Where
Lordship,
did he mention in any other places in page 79?
peruse the report of the Superintendent of Police, Sonitpur District, dated 14/8/2017, wherein it was reported that no land records were found relating to Chitraban Bakuri.
Huh? When
And
therefore he
permission may
says
be
there is no
considered-
land records found relating to Sidra and the permission may be considered considering the land records of the safer as well as in the light of so and so.
Exactly.
So therefore this was the word Chitraban Bakuri was used by in the permission on the ground that they have used it. That committee who applied used it for national road.
Authority has, Your Lordship, I am showing the letters, Your
Where?
Lordship. That's it, number of letters, Your Lordship.
No.
Can-
Go there.
Your
Whether it is
Lordship,
Chitraban Bakuri or not is a subject matter of
Your Lordship will come.
Lekho, heard Mr. S. Ali, the learned counsel
Lordship,
appearing
come.
on behalf of the
Go.
petitioner. Who appears the other one?
I appear for the reform number, my lord, 3, my lord.
Absolutely, this court, they are not going to look into all this. Miss S.
One minute,
N.
Your
Bodloy
Lordship.
appears for the respondent number one. N. Bodloy appears for respondent number one. S. Sharma appears for respondent number two.
Lordship will come
You are number three.
Number three.
7A,
So
Your
and so
Lordship.
appears for the respondent number
7A,
three.
Your Lordship.
Huh?
7A annexure.
No, all
50,
7A is for the
50,
Supreme
Your
Court,
Lordship.
either the division
It is
bench
being
or the
used.
civil court.
It is
The
being
petitioner
used by the-
herein,
It is being used by the authority, Your Lordship.
the petitioner in the instant proceedings herein is aggrieved by the use of the word
And if
Chitrabon Bakori in the field which have been reserved
Annexure 7 and Annexure 8 series, Your Lordship will find. The authority has used the
which
word
have been
Chitravan
field
Bakuri.
which have been reserved for Tezpur Idgar Committee for the purpose of
And his name is being used since 1923, Your Lordship.
Eid prayer. It is also seen that this land is situated in Dag number 1828 and 1829
29.
under Moza Mahabhairav. And the said land is a Sarkari khas land and to remain in the custody of the Deputy Commissioner. Dorong, who will, whenever necessary, give permissions for games, holding social and public functions, etc.
Now the name of the district is Sunitpur. Madam.
This aspect of the matter can be clearly seen from the order passed by the division bench of this court dated 25/11/2016 in PIL number 100/2015. The petitioner herein is aggrieved that in the permission so granted on 14th of August 2017 for the purpose of hosting the national flag on 15th of August 2017 to a committee in the name and style of Bharat Mata Pujan Committee. The Deputy Commissioner, Punitpur, have used the word Idgar Field bracket Chitraban Bakori and has therefore approached this court, submitted a representation not to use the word Chitraban Bakari with the Idgar field. First. This court had put a question to the learned counsels appearing on behalf of the parties as to what is the term Chitraban Bakori means. It has been submitted that the term means, implies a beautiful courtyard. Isn't it?
Yes, ma'am. Bakori means actually field.
Be it as it may, this court finds that the land in question have only been reserved in the name of Tezpur Idgar Committee, but not yet allotted. It still remains a government khas land. And taking into account the order passed by the division bench, this court finds no reason to entertain the instant writ petition. Wherein a question is raised as to whether the Idgar field should also be referred to as Chitraban Bakori. The petitioners, if so aggrieved, are at liberty. No, Bakori, Kusto. This aspect would also require evidence to be taken. Kusto. The petitioner, if so aggrieved, are always at liberty to approach the competent court of civil jurisdiction in that regard. The above petition stands.
Lordship, at least fill that they have to be arrested, your lordship, from adjoining town, Citrobon at least. The first order may be perused, your lordship. And that order says, your lordship, this,
Interim order passed any can vacate. Ding ding. Go to yes, what is this?
In item two, Lordship, we have been directed to file affidavit and on behalf of the Deputy Commissioner, it is filed today, Lordship. So may I pray, Lordship, tomorrow or Monday? It's not
Hello?
in the record, Lordship. As because it was filed at about,
You have got compensation.
Not yet.
that is why, Lordship.
Why haven't you paid the
No,
compensation?
Lordship, that affidavit will be as because we are the common, if you're, my copy, Lord.
Give it to me.
One
Adjourning a
letter was
matter for
written-
that
No,
doesn't.
Lordship, your Lordship may kindly peruse paragraph 4 and extra copy. তোমালোকক দিছে ন? অকমান জনাব। We are asking for certain. The railway is also here, Lordship, is that direction. If we get that, that will be convenient on our part.
Who is paying for the railways?
Most
Paragraphs comment, will file affidavit.
Lordship, I will serve a copy of this affidavit to her. Most probably this affidavit one, I know.
Meaning thereby, the land of the petitioner have been acquired.
Lordship, we are not denying that.
The petitioner is entitled to compensation.
Lordship.
Railway says that the amount has been deposited to you. You said that you have not received.
They have, their statement is that they have given us the check. So we are asking for the details of that so that we can find it out and pay him, Lord.
And for
We are not denying the risk part, Lord.
Oh,
that
how
is-
long? How long? This happened on 23,
Yes, yes.
2024.
Yes, Lordship.
We are
we
today.
are ag-
What is this pairwise comments and all? We have done, this is nothing, these matters do not require adjudication. Only require is a strict adherence to the timelines. When are you going to give, both of you, when are you going to give it to the petitioner? Your land has been taken away.
Yes, yes.
Okay, take back, give it to them. Have you constructed any railway bridge?
It is done, Lordship. as
No, no, no.
92, Lordship.
You give that land back to him. You take back. I'm passing an order. If you don't do it, give back the land, you break that.
No, Lordship.
No, no,
we are-
nothing doing. How can this happen?
Yes,
It is
Lordship.
absolutely a careless
I agree, I
attitude
agree,
of the circle officer with the
agree.
railways. And you railway, you come over, tell, I'll file affidavit. What is this? Can a matter of 2022? We are in 2024.
Only this much of intimation, Lordship. We are
Tomorrow, 2 o'clock. 2 o'clock, get your information ready as to why this has not been, why this is become, both of you, this is happening. He's entitled to the money, he should get it. Tomorrow, this is the matter tomorrow on which date? The council appearing, yes, what is it?
Item number, maybe take with item number 17, Lordship.
Let me pass this order here. This is the matter tomorrow at 2 p.m. On which date Mr. H. Sharma as well as Miss so-and-so appearing on behalf of the district administration and the railway authorities shall apprise this court as to why there is a communication gap between the state authorities and when the amount would be disbursed to the petitioner, giving a positive date. Full stop. If such an instruction is not provided, this court would be constrained to call for the personal appearance of the respondent, the concerned respondent authorities.
And sorry to step, Lordship.
What?
We take with item number 17, which is.
Why 17? 17 is 17 is 17. Now we are in 2.
No, in tomorrow list. It is in the tomorrow list.
there is the copy of that. Even later, we made a photo of
17 is what?
Item number 17 in tomorrow's list, Lordship, which is in the motion list. Lordship. There is a matter which is similar.
17.
Tomorrow's list, Lordship.
In tomorrow's list, Lordship, not today's list, Lordship.
Mr. Council. Tomorrow is another day. I only know what is there today. Get your information. Why this communication gap? And when are you positively paying?
মই এটা কপি এটা তোমাক দি আছো এতিয়া এই হেৰিখন যাই যোৱা না
Please, your lordship.
Yes, Mr. Bachchaji.
Just now I have received a affidavit wherein
While acquiring
This
land
is
for
stated that my
establishment
land
and
is in the
application
possession of
by
the-
area
FCI, my lord. And the compensation was not paid yet.
some order passed somewhere.
Yes,
Yeah, I passed an order here,
yeah, earlier your lordship has passed it.
isn't it?
Yes.
PK Singh. This matter should have been over long time back.
Government was taking time for filing the affidavit, my lord, and lastly,
In the meantime, Mr. N. Gustami so and so shall apprise this court as to whether the land measuring 1 katha
17.
17 letters covered by DAG number which admittedly belongs was acquired in so and so. So and so, when in it is mentioned the land measuring belongs to the petitioner and the said was beyond the square, it was mentioned as so and so. The learned counsel on behalf of the respondent has submitted the land of the petitioner is presently under the occupation of FCI. BCCI shall seek to obtain instruction as to whether what caused the FCI. Now, after that, then also matter is pending. How can it be?
Government was taking.
Who is appearing for FCI?
And for the respondent 4 and 5.
Yes, what is it?
My lord, my senior is on another court, so.
Who is your
may I-
senior?
BK Singh.
When is he
May I
coming?
please call? No. May I please call him.
2 o'clock. 2 o'clock, get him. Else, this court is directing the air authority to demolish whatever you have constructed and hand over the land to him. I'm telling you, this happened this order should have been passed in the month of June 2023. We are in August 2024. Yes, what the instructions you have got as regards the land? It is an admitted fact that excess land is with you. You are a
We
state.
are not admitting, my lord.
Okay, then we direct the circle officer to demarcate and give him whatever.
And in our presence.
Your presence or whatever your presence is, I'm not concerned.
My lord,
That
we
they are,
government-
because the circle officer categorically says that 1 kata 17 lectures of his land is under your possession, which went in excess. So if that is why on the last
and
time
we
when the
were supposed
matter
to
came,
file the affidavit, my
no affidavit business. That is 1 year have passed. I gave you an accommodation then, and then the matter has been revolving out there all this while. Nothing doing. We are the state, otherwise the state has
My
to
lord,
pay
kindly-
from their own.
kindly-
Nothing doing.
Kindly, my lord, come to page number 37 of my affidavit in opposition. My lord.
What? What is there?
Annexure C. Page 37, Annexure C, my lord.
Yes.
Gazette notification of acquiring the land, my lord.
Yes.
And patta number 331,
Hmm.
dark number 1693.
Hmm.
That is the petitioner's land, and the what was acquired is 7 chatak, my lord.
Hmm.
So this land was acquired and given to the FCI, and accordingly we have made the full payment, my lord.
Understood. That is not the issue. Mr. Singh, that is not the issue. The issue is very simple. Another additional land was taken and handed
Yes, this
handed
is
over
the
to you.
additional land, my lord, Annexure C, my lord.
No. This
Earlier
is the
they-
only
earlier-
7 sataks of
earlier
land.
What they have acquired is Annexure A, my lord, page 33, my lord. Then subsequently, the government has stated that some additional land, so that is 7 because has to, we are acquiring, you have to take it. Then we have taken it, my lord. That is Annexure C, my lord. Now,
This
if they have,
happened earlier.
if
This-
they have
no,
done
this
some
I'm
kind
not-
of,
no,
if
this
the
I'm not
government has
concerned.
done some kind of, my lord, inquiry, that is behind our back. Let it be done
Nothing doing
in
it.
front of
It
us,
has-
my lord.
I gave you 1 week. After that, what affidavit you have
After
filed?
that, my lord, kindly see the last order, my lord, order dated 18/3/2024
No,
of the
no,
Honorable
no,
Court, my
no.
lord.
Those
It was
orders, forget about
specifically
those.
given that kindly
No,
whatever they
Mr.
want to
Singh,
say, they may
af-
say on
No,
affidavit, my lord.
no, nothing doing. What order after this order, what affidavit you have filed?
No, we have to file affidavit. That
No,
government was
after
instructed to file
20,
their affidavit.
Mr. Singh, after passing of the order on 26/7/2023, what affidavit did you file?
My lord, they, on 18/3/2023.
I'm asking you, after 26/7/2023, what affidavit did you file? That earlier affidavit was already there on record.
Yes, my
And
lord.
therefore, I asked them, and they came up with a categorical observation to the effect that this is the additional land which is there. And you said that I will take instructions. Thereafter, what up? We'll take it up at 2. Come up. Cannot take this land like this.
May I plead your lordship?
Yes.
Lordship, I am suffering for fever, lordship, so I pray some accommodation regarding item number 12 and 13, lordship, next week.
Is the
I have taken
matter,
consent about.
is the matter in the month of December 2024.
My lord.
At number 1 to 11 pertaining to Kohima bench.
The affidavit filed last time.
One is this one. This is the first one. This is the second one.
Lord, I've examined the matter further. I've called the officers also to know exactly where we stand in this. They have quoted various judgments, rightly so. They are more pertaining to regularization, etc. Uma Devi case. This is a case of existing vacancies. Appointment is to a regular post. But at the same time, when we speak of open advertisement, which is a mandatory requirement in terms of both 14, 15, and 16 of the Constitution, no doubt that has not been followed. I'm not here to justify that, but that has happened. And as far as the service is concerned, it is not that they were not qualified. They were all qualified for the post. It's not that without any qualification we appointed them. Pursuant to their appointment, they were put to test on the ground, various assignments, various election duties, various postings in sensitive areas. Sometimes some of them have lost their lives also. It is all excellent and very creditable. These are the people whose fate is there before your lordship today. I also quoted last time, though it was not much in favor of your lordships, the judgment pertaining to the district judges before the constitutional bench. that constitutional bench judgment
Yes.
pertaining to
Allotment.
the
Number 1 to 11 pertaining to Kohima bench.
Yes.
where, my lord, where the district judges, there was some error in their appointment regarding some terms or not.
Affidavit
Where
filed.
the court took a little lenient view. Now, my lord, I'm not seeking that benefit. which I'm not entitled to.
This one, this is
But
the
at the
first one,
same
this is the second.
That principle which they said, where will they go? They have also put in so many years. So you can't just throw them out. They found a method of accommodation for them in their judgment. We are not seeking the same relief, especially when your lordship reacted to the judgment for that placed before your lordship. All fair. So in these circumstances, how do we accommodate them? Now, whatever judgment is there, which says that without open advertisement, it is wrong. That's a general principle of law. There may have been many bans, and your lordship knows in Nagaland, once there is a ban, next time they go ahead in spite of the ban. It's a customary practice. So I'm not getting into all that. So we have to now see how we can, I would say, retest for the simple reason that there is admittedly lapse in the appointment. Only on that point. All other points, they're satisfied. Now, if they're put in about 5 years or 6 years, we have that superannuation age. Examine the matter. We have that further old case. Wherein where we stand in this. The old case of various judgments, rightly so, pertaining to regularization, etc. Kumar Reddy case. May I speak? This is a case of
There's
existing
something.
vacancies. Appointment is to a regular post. But at the same time,
Ms. Chimomi,
speak of
if you just mute yourself for the
The
time being,
mandate
let me hear the advocate general.
terms of vote 14, 15 and
Yes.
16 for the constitution. I was thinking that somebody is arguing against it. That has not been followed.
It is being repeated.
I'm not here to justify that, but that has happened. I can speak without the mic. And as far as the service is concerned, I can continue otherwise. It's not that they were not qualified, they were all
It's being
qualified.
repeated, what you say.
Not that without any qualification. I actually thought somebody is opposing me. That's why. Pursuant to their appointment, they were put to test on the ground.
We will hear
Take
you, just
assignments,
give me
various
some time,
elections,
because
various
the
postings
matter has to be taken
areas.
with them also.
Some
So
of them
there's
have
some
lost-
problem with this.
We'll wait.
Just wait for 10
Wait
minutes,
until
let the
very
people
correct
come.
them. These are the people who
We
say.
will take it after some time, okay? Yes. Yeah. Be on the
I don't
line.
know.
There's no problem with that.
Lordship.
It was not much in favor of your lordships, the judgment pertaining to the district judges before the
Hmm?
constitutional bench. The constitutional bench judgment
Yes.
pertaining to
Allotment.
the
Number 1 to 11 pertaining to Kohima bench.
Yes.
where, my lord,
33.
where the district judges
So may kindly come to Annex
Yes.
3, my lord, page 14.
Yes, Mr. BJ Talukdar.
An affidavit is being filed today, man. We have soft copy on that.
Does it take so long for the person to file an affidavit?
And there was some
This
prob-
affidavit was directed to be filed as far back as on 5 months back.
There's some problem. with
I
the-
think we call the deputy commissioner who is in charge out here to be present.
And it is a fact that the land.
We'll
is
take it up. No, nothing
in
doing.
their
The
possession.
problem arises because of the excess land of his you
Yes.
have handed it over.
Yes, ma'am.
So you
A report
carry
is-
out you carry out the demarcation. If you find his land out there, kindly give it to him. If there is houses,
Actually,
demolish.
There, my lord, there are two reports of the circle officer that the land is now possessed by them. Yes,
Understood.
ma'am.
Then also they say that they are not. How do you find it out?
It has to be find out. ma'am.
We'll keep the matter pending. We'll have it after a few days. Get the demarcation done. Where is it? In Guwahati?
Not what?
Not Guwahati, not far off. It's just across the river. So we'll have it in 1 week's time. Get the demarcation thing done and we'll take it up. Passing that.
Can lordship may indicate that in.
Yes, I'm passing the order. Matter after this order which I passed on the last occasion, there was no sense of keeping this matter pending for such a long time. The present petition has been filed by the petitioner. Being aggrieved on account of non-payment of compensation on the ground that a land measuring a plot of land measuring 1 katha 17 lechas covered by dag number 1693 included in periodic patta number 331 located at village Sangsari have been taken over by the district administration and handed over to the FCI without following the due process. The case of the petitioner squarely comes within the ambit of Article 300A of the Constitution. Under such circumstances, this court, while taking up the matter on 21/7/2023, directed the Deputy Commissioner, Kamrup, to apprise this court as to whether the land measuring 1 katha 17 lechas covered by dag number 1673 and included in Khiraj Miyadi Patta number 331 of village Sangsari belongs to the petitioner and was acquired in LA case number 1/2007. And thereby fixed the matter on 26/7/2023. On 26/7/2023, an instruction was placed before this court, which have been kept on record and marked with the letter X, wherein it has been categorically mentioned that the land measuring 1 katha 17 lechas bearing dag number 1693 and included in patta number 331 belongs to the petitioner, and the land is in occupation of the FCI. And the said dag and patta number is beyond the ambit of the acquisition from the ambit of acquisition made by the additional deputy commissioner, made in LA case number 1/2007. And under such circumstances, it was mentioned that the that a communication have also been issued to the General Manager, FCI, Regional Office on 5/11/2010 for payment of compensation for making an outright purchase of the said land. In view of that, this court fixed the matter again on 4/8/2023, taking into account that the counsel appearing on behalf of the FCI sought for an accommodation. It is further seen that on the same date, that is on 26/7/2023, an affidavit in opposition has been filed by the respondent number 4 and 5, wherein it has been mentioned that in the LA case number 1/2007, there has been various lands which were acquired for construction of the FCI godown. Footstep. The notification in respect to the said LA case number 1/2007 have been enclosed as Annexure A to the said affidavit. And from a perusal thereof, it is seen that the land bearing dark number 1693 or patta number 331 is not a part of the said LA case number 1/2007. Be it as it may, it is also seen that there was a request being made by the additional deputy commissioner for acquiring additional land of 7 bighas 2 kata 9 lechas. And in pursuance to that, a proceedings was initiated, being LA case number 3/2012. In the said declaration so made in LA case number 3/2012, it is seen then 7 shatoks of land. What is the 7 shatoks have anything to do with these type of lands? If it is in North Guwahati, where does this shatok business come out here in Brahmaputra Valley?
It's not there.
7 shatoks of land in respect of dark number 1693 or patta number 331 was a part of the said acquisition proceedings, being LA case number 3/2012. It is, however, not understandable as to the use of the expression shatoks in the declaration made in LA case number 3/2012, taking into account that in the Brahmaputra Valley, The measurement of the land is taken on the basis of biga, kotha, and leta, or in hours, and not in full stop. The unit of chotok, however, is only prevalent in the Barak Valley. Full stop. It is further seen that in view of the petitioner claiming compensation in respect to 1 Katha 17 lectures of land covered by Dag number 1673 of Kiraz Miyadi Patta number 331, a letter was written by the Assistant General Manager to the Commissioner and Secretary to the Government of Assam, Land and Revenue Department, stating inter alia that it is that the FCI only is in possession of the land which have been handed over, which have been acquired and handed over after due demarcation, and as such requested the said departmental official to look into the matter. Pursuant thereto, this court, by an order dated 18/3/2024, sought a clarification from the Deputy Commissioner, cum Collector Kamrup Amingaon, by filing an affidavit, thereby fixing the matter on 29/4/2024. But for reasons best known, till date, no affidavit has been filed. The non-filing of the affidavit by the District Deputy Commissioner, cum Collector Kamrup Amingaon, is on the face of it an infraction to the various directions passed by this court, to which this court takes judicial notice of it. What consequential orders is required to be passed shall be passed by this court. No. What consequential orders, therefore, requires to be passed? This court finds it relevant to hear the District Commissioner cum Collector Kamrup Amingaon in person. Accordingly, this court fixes the matter on 22nd of August 2024, on which date the District Commissioner cum Collector Kamrup Amingaon shall file an affidavit as to why, in spite of specific directions to file an affidavit, have not been filed. And in addition to that, shall also clarify the stand as sought for in the order dated 18/3/2024. In the meantime, this court further directs the District Commissioner cum Collector Kamrup Amingaon to carry out an exercise of demarcation and to find out whether the land of the petitioner is in occupation, is in possession of the FCI, whether any part of any portion of the land belonging to the petitioner is in occupation and possession of the FCI. The report also be submitted on the next date. The presence of the Deputy Commissioner, District Commissioner, Collector would be at 10:30 a.m. on 22nd of August 2024 through video conferencing, through the video link to be provided by Mr. B.J. Talukdar, the Learned Counsel. Taking into account that the matter has been substantially heard, the matter be shown as parted.
FCI officer will also be present before.
I am not there. I'm not bothered with that, what FCI does. You have taken only 7 chotoks of that, and chotoks have no business out there.
Right.
11, pertaining to Kohima bench.
Yes, Mr. Advocate. Mr. Advocate General, the Constitution Bench judgment would have no application here. Taking into account the facts in the Constitution Bench judgment is different. There's no quarrel with the fact that there was a proper selection process. However, there was a mistake which had been done by the full court and which had resulted in taking into account certain persons, the rules having not been taken into account properly. An amended rule was taken into account which was yet to be amended, and therefore whatever way. The reason why it was done so, that there was, these people were not only selected properly, there were proper selections being carried out. Apart from that, there were various orders being passed, and to make it honest would have a far-reaching consequences. Here is a case where there is a requirement, a constitutional mandate of holding advertisements and then to proceed. The only point on which I asked your assistance on the last time, if I remember, before the in the Kohima bench was, law is one and the other is the justice. How do you take care of these people? Obviously, their appointments have to be set aside. The only thing which can be done is, can you provide some relaxation for them? Nothing more than that.
I was only coming to that, and I quoted the Supreme Court judgment, not to compare it with this, as specifically mentioned to your lordship. I'm only saying that a small element of their difficulty also has to be taken into consideration after giving absolute respect to those judgments which specifically mandate that you have to go through the process of advertisement. So I have looked into that aspect also. So the first point is, we have the Nagaland, the Superannuation Act, 2009. I had done this matter here at that time, also in Supreme Court. So we have a particular age at which they should retire, how many years of service extra is there. I think here the entry point is 35 years. For that matter, for any service in Nagaland. So most of these people are beyond that bar. So in the first step itself, for being eligible to be appointed to the post, the first boundary which has to be crossed is relaxation in terms of age. Taking into consideration, they were not sitting idle. They were doing the same job right from the inception. And when they were appointed, they were qualified to be appointed age-wise. This is my first submission.
Therefore, your affidavit should have been centered on that.
So I'm coming to the point. I'm coming to the point. Why I didn't want to straight
Exactly.
away go ahead with the specific details was, I thought I'll first seek your lordships. That these are the things which I have in mind. It was not proper on my side to say, give me this or give me that, especially when I have not complied with the law. So my advice was, you fix up this. I said, I won't. First, I'll have to explain to this honorable court. After that, it is only whatever they say, I can put in the form of a list for your lordship's kind consideration, and your lordship can pass orders appropriately. That is why I didn't particularize that give me this or give me that. So this is the first portion. Then we come to passing the exam. I was just telling one of my friends now. Today, if we were to write, at least people like us who are not very bright students, if we were to write the LLB exam, even of ST years, we may not make it because time has passed, our experience has changed. We may show proficiency in other fields. So like that, these people who have put in 6 years service on the field, they may not be competent to compete with these people. But taking into consideration the fact, it's not empty. They did a wonderful job. They risked their life, especially during COVID. We had a huge area where these people were brought from railway stations and airports, all kept there. These people did all the job, which are expected to do. They didn't do any favor. According to what they should have done, they have done it. It is not their records were bad. Records were bad, no concession. So in the light of this, some concession should be given as far as these examinations are concerned. Then, my lord, then we come to the next point, and that is the sport activities. That is the physical fitness. What they could do, supposing to run say 10 rounds in 20 minutes, they could do at that age. Time has lapsed, madam, 6-7 years. They may not be able to run that much number of rounds now. Though they are more qualified than them to do field work, which the others are yet to acquire, which may take about 5-6 years for them. So keep
No, Mr. Advocate General, if I remember, while taking up one matter in the Kohima bench, I was sitting in the division. You had something to do with this when these certain doctors were appointed at that point of time. You came up with some circular to the effect that these doctors out there, they will be given some marks. You have a circular for that. That circular which says that these doctors who were there, appointed at that point of time, they were given certain marks at the time when they were saying that you are, because they were initially appointed without any proper method. Thereupon, the government came up with a particular circular that, yes.
That was actually a case where, speaking from memory, my lord, that certain people had to follow a particular procedure. Whereas when it came to doctors, because they were highly qualified and their services was required for appointment, they were given a specific concession. That I can take it out and I'll place it for you.
No, I remember.
I'm grateful, I remember.
No, that is why I would
I
say,
remember that.
you come up with those types of
I'll
things,
come
that
up
is
with
your
that.
thing.
So I'll do that. So as far as the sports activities are concerned, I have mentioned this to your lordship.
But there are some of the appointments of the year 2021, isn't that, madam?
20.
Huh?
2020.
They're all after 2000.
They happened just before the COVID.
Yes,
Sometime in
Lordship.
February.
Lordship.
When there was no COVID, COVID was in Wuhan, and
Lordship.
Nagaland government thought that Wuhan, this COVID will be necessary, and as such, COVID will come, and therefore we need this expertise and appointed.
Fuming at that time. I only said that when my lord,
But it is just 4 years.
when they were appointed.
Yes, 4
But
years.
Mr. Advocate General, it's just
Yes,
4
Lordship.
One has to take note of 4 years,
I'm only saying this, my lord.
and that too in a police service.
I'm only saying this.
Have to be fit.
Like you want to, I've been a sportsman myself, my lord. I know how it is at
Yeah.
one age and what happens after a few years. That difficulty is there. They won't be so well equipped.
But it's just 4 years.
That's right. 4 years is not a
Exactly, Lordship.
Short,
it-
but one has to take note of
That's right.
that. Therefore, I asked you that kindly come up. Yes, you can give some
There-
concession that these people have worked out there all this while. They have rendered
that-
these type of services,
that-
and as such, because there has been a cabinet decision which was taken in those type of medical doctors. Why not the same thing? You can very well adopt that. There's no quarrel.
We will take
They should have next second.
that fact also. So I am not saying before your lordships, give me so much percentage or so much percent. That would not be fair. Though that was what they were contemplating. Whatever it is, I'll explain my point and what may we may like to have that also, I'll put before your lordship, and everything will be left to your lordships.
No, no,
some of
don't
them-
leave it to me. So
Okay,
everything,
I'll put it. I'll
my
put it on record.
limited list
I'll
out here.
put it on record.
Uh,
Since your lordship has
No,
said
that is, no, that
I
is
put
what
it on
I
record.
wanted to be
I-
put out
I
there.
put it on record.
Yeah.
I felt that it would be a sort of impertinence putting these things and asking the court, after being a violator, give me this or that. So I thought, first, let me clarify the position. It's only keeping that in mind, I had done this. So now I'll put specifically what exactly we have in mind, so that then we leave it to your lordship. So then we have the return.
No, definitely, the age
I-
relaxation has to be taken note
So-
of.
So there,
And
I'm
there
grateful.
would be also the aspect as pertaining to, you may have a similar thing which you had for the medical doctor,
Right,
but,
that-
but whatever maybe you have should be such
I'll
that it
put
should not also be, in a such, it should not be a such an arbitrary concession, thereby
Yes,
affecting
exactly,
the
Lordship.
rights of
Exactly.
those persons concerned who would at all apply.
We will see the
We
balance.
leave it to your best wisdom of the Advocate
We
General.
will definitely see the balance. And since what has come from your lordships, now we'll prepare a real clarificatory process, which I will place on record. If your lordship feels appropriate, if you have to appear, I can come on 19th. I'm coming on 19th, it's not too far off.
19 of what?
19th of this month, my lord. If it's okay with your lordship,
19th, okay?
yeah, I will come. Before that, I will place this on and leave it to you.
Bring it on.
Lordship,
I'm not
Lordship.
contesting the various judgments. In fact, many were appointed even 2018. Different periods they were appointed.
Oh, okay, but
That-
Mr. Advocate General, you have to understand one
I
thing.
understand,
Giving any sanctity to this type of appointments will have a far-reaching
I
consequence in the state of Nagaland,
I-
which is
Lordship.
already suffering because of this.
Exactly, Lordship.
further, my lord, further, I've given an undertaking by a responsible officer before this honorable court that henceforth, let it be at least the final shock in these type of appointments. And as far as future appointments are also concerned, we are going to reinforce it to see that it is much more foolproof, because we can get the best talent. Many times we may like to appoint, give some post to different tribes. You have so many tribes, so they're not completely exclude you. If there are eligible candidates, they can also be taken into consideration. So
Whatever you may have
We will
some,
do that.
now recently the Constitution bench already said there can be a subclassification of
Within college.
within the within the
That's right.
within the
Right,
SC
right,
ST.
right.
So understand, you can very well do so. Those are things which you can very well do.
So I will
I'm
do it.
not on those. Only thing is this type of whatever you have done out here in this case, these appointments have to go. Only thing is how to take care of something as regard those persons who have been appointed. Something has to be done.
Right.
Because they also, all said and done, whatever
Big
they have,
effort.
they didn't get the job just for
That's
the
right,
sake of it. There is some good reasons for that.
That is why the inception itself, I said that we have no defense as far as that part is concerned. We are looking into this. I'm grateful to your
Okay,
lordship.
heard
I'll
Ms.
file.
M.G. Mahoney, the learned counsel appearing on behalf of the petitioners, and Mr.
Hello, I
K.
need
Balagopal, the learned
well
advocate.
placed, your lordship.
Vice versa.
Koyama. My lord, Koyama, yes, 19 is a holiday for our Koyama.
That is better. So you be at home and do it in the comfort of your home. Or we can take it on 20.
Well,
Yeah,
yes.
my lord, they can,
19 is open here, but 20 we can do it because you see 19 is otherwise a very busy motion day. Have it on
Lordship.
Monday, it's a Monday.
19 is Monday, Lordship.
20.
And
Yeah. so
Tuesday is 20.
20. We'll have it on 20.
Lordship,
20.
very well.
Lordship, I pray that this may be the last chance.
No, it's okay. I'm making it clear. No?
Lordship.
We have not made any contest. Please understand. We understand the
Yeah.
problem
First,
and we are trying to address it.
I also heard Mr. So-and-so and Mr. Imti Longshar, the learned counsel appearing on behalf of some of the private respondents.
My lord.
This court have also perused the affidavit which have been filed on 24/7/2024 by the respondent number 4, 5, and 6. The said affidavit, however, do not answer to the queries which have been raised by this court on the last occasion
Exactly.
as to how, as to the intention of the state government, as to whether, as to how the answer here as to what steps the state government would like to take in the eventuality, the appointments of the respondents,
It is the home department.
private respondents,
Allowed me correct it.
Hmm?
Restricted to the home department. Only home.
by the
They will correct it.
by the government of Nagaland is going to take
It will be in the home department specifically because.
in the home department. In the circumstance, this court sets aside the appointment of all the private respondents. The learned Advocate General submitted that there is a requirement of taking into account a requirement of granting some concession in such eventuality in view of the fact that some of the private respondents may have already crossed the age bar in view of the Nagaland there's the act, no? What is the Naga? In view
I'll
of
just pass it on.
Nagaland so and so act. And further, some marks may also have to be added, granted to those people who have rendered service during the time when the COVID some marks has also some grace marks also has to be granted. Some concessions have to be granted, made in respect to the services rendered by these private respondents. He therefore submitted that he would take up the matter with the government and place the decision by filing an affidavit. The affidavit be filed by 19th of August 2024, and the matter be listed again on 28 2024 at 2 p.m. through video conference.
Much obliged.
Liberty is always given to the parties to appear in the physical mode also.
Principal seat.
Yes.
Roman,
Mr. A.K. Talukdar, what is this?
the matter is, fixed on 12th of August, before the Honorable Supreme Court.
What is this?
That's whether the limitation would apply in a case of Section 17 petition.
Okay, then. Where is the 12th of August?
12th of August is the case, that is, Milord, I'll just KJ George case, Milord, which was pending before the Supreme Court regarding the same point.
Pending, it's fixed.
It is fixed on 12th of August.
Has been submitted by the learned counsel appearing on behalf of the respondent that the issue involved in the instant matter is pending before the Supreme Court in the case of
KJ George versus and another versus authorized officer, Indian Bank and others.
Huh?
KJ George.
Give the name. Mr. They give the name by writing or whatever may be.
Lordship, find it in the judgment with Madhya Pradesh High Court, that is before Lordship.
Who has referred?
I had referred. The division by judgment of Madhya Pradesh High Court.
Huh? Hey, it is pending before you give the name. So and so, yeah, which is likely to be listed before the Supreme Court on 12/8/2024. So, taking into account the above, list the matter again on 10/9/2024. Interim order passed earlier shall be.
For hearing.
Yes.
Matters released to my lord. On non-issuance of transit pass. The petitioner for transporting the Vadgila barks, my lords.
I have filed one additional.
Huh?
affidavit. I have filed one additional affidavit, Lordship. Regarding the judgments of honorable.
Did you file an affidavit?
Additional affidavit, regarding the judgments.
Have you filed it? When?
30th day of July 2024. It is on record. Page starts.
1st of August.
Page starts
2000.
from 12.
Now, as per the Forest Act, if we are a forest regulation, the property becomes the property of the state when? When there is a confiscation done? Did you confiscate the proceedings?
Only sent.
Huh?
Yeah,
You did not, because it got fired, it got destroyed.
Yes.
So before the confiscation proceeding being over, how did you? The petition, isn't the petitioner entitled to the amount or for the bark in question?
But bark, carrying and transportation of bark is banned by the Honorable Supreme Court.
Huh?
Carrying of bark is banned by the Honorable Supreme Court.
So whatever may be, don't you think that there has to be some decision by your authorities?
So this is, at one time, point of time, authority is allowed to transport him outside Assam.
Where does it
Yes.
say that the scaling of bark is banned?
I have stated, Lordship.
Where?
Lordship. There should be a plan as per Honorable Supreme
Huh?
Court guidelines.
Page?
There should be a plan, Lordship. Page 214.
Huh? 200 and?
14 of my affidavit, Lordship.
Yes, working plan.
Working plan, Supreme Court has directed.
All forests shall be prepared by the state government and got approved from the government. Forest working shall be carried out strictly in accordance with the approved prescription. The working plan should be prepared with a 2-year period of 2 years. During the incumbent, the forest shall be worked according to the annual felling program, and in case of is not prepared within this time, future felling will remain suspended till month. the forest under the so and so shall be worked in accordance here, the maximum yield area in the year so and way. In view of the issued letters dated so and so, removal and transport and demand. In view of the above, the MOC has issued letters dated MOC issued dated so and so, intimating that removal of transport any key existence of a or scheme is prima facie illegal, and to ensure that no transportation of such and to mention that the dead, deceased, dying, or when did this thing happen?
In 2012, my lord.
2012. And you say that there was no working plan. Huh?
Actually,
There was no working plan in 2012, in spite of this letter being issued on 34/2004.
lost.
When did you start having a working plan?
That has not been mentioned, but he allowed first time to transport outside the state, but thereafter.
No, madam, I'm not on that. My question specific is only because of the working plan. You said that this incident happened in 2012. These letters were issued in the year 2004, categorically say that without having a working plan, kindly don't go ahead it. Now you went ahead
Some mistake.
without a working plan.
Some mistake has been done by the.
Huh?
Some mistakes, I think, done by the authority lost.
Whom?
By the authority earlier lost,
How?
allowing him to transport outside.
No. I'm asking you whether you have a working plan as of today also. Because you are saying that because of there being no working plan, it is fair or removing the barks is banned. Should not be done because there is some language used this prima facie, it would be illegal without a working plan. Now, under such circumstances, when did you start having a working plan? Or is the removal of bark has been banned from 2024 till date? Where? Are you saying that there is no removal of bark in BTC area since 2004 till date?
Have not mentioned.
This is the pointed query. Whether you have a working plan or not. And what was the amount? Value of the barks?
I have stated, my lord, he has invested about 25 lakhs, my lord.
25 lakhs. Okay, make it into 18% into 12 years. Get ready with that money. Or 8% money. And then you have to pay it to him. Get ready. Or find out when you had the working plan. Did you have a working plan at that point of time or not? You can't take anything in your custody if it has been destroyed without a confiscation proceedings. It is his property. Admittedly, there is no confiscation proceedings under that. Is there a confiscation? No. So therefore, it did not become your property. When it becomes your property would be after a confiscation proceedings. as per the Assam that forest regulation. And if you did not have a working plan, that order was passed on 34 that if you don't have a working plan. State of Arunachal Pradesh had a working plan as far back as in 2004. And you mean to say that the BTC is not bothered? Forest is with you. BTC. God save BTC. That is the only thing I can say. And there is no working plan. So this means the BTC can do anything. They will take an action against some whom they don't like on the ground of working plan is not there. Why is the working plan conceived of, madam? So that there is a particular manner in which it is to be done. And you mean to say there is nothing? This is the pointed query to you. And you have failed to satisfy whether there is a working plan or not. Or when did you first have the working plan? 25 lakhs, 8%, 12 years. PTC earns a lot of money from revenue, giving all these advertisements, send mohals to get it, to pay him. This is a very old matter. I have taken many times, I suppose. Then?
Earlier.
Then? Because I remember that. On the last occasion, Justice Goswami was delivering the judgment, then you come up with this.
Yeah.
And now you don't know whether there is a working plan. This is done under whom? Who is the official? Oh, this official is there, na? I think better off we ask him to be present. APCCF come CHD Forest Boroland. List this matter again on 13th of August 2024. The deponent of the additional affidavit, one Mr. Suman Mohapatra, who is the APCCF come CHD Forest Boroland Territorial Council, shall be present at 10:30 a.m. through video conferencing link to be provided by Mrs. R.B. Bora, the Standing Counsel of the BTC. On the said date, this court shall inquire with the said officer as to whether there was a working plan, whether any working plan has been prepared for the BTC area, and if so, when it was prepared. In addition to that, the said officer shall also apprise this court as to whether any confiscation proceedings were done in respect to the seized barks belonging to the petitioner. Better he will answer. You only take the instruction. How much you are going to pay as compensation? 25 lakhs, 8%, 12 years.
No, 5 and 6.
The Lordship will kindly peruse the last order in item 6. The matter pertains to delimitation of Tiwa Autonomous Council territories. There have been, it's a statutory mandate. There have been directions issued by the division bench of this honorable court. Initially, it was directed, the chief secretary was directed to take a decision. He, instead of taking a decision, he referred to a referred the whole issue to a group of ministers, and since then it has been hanging like that. And on the last occasion, specific order was passed that they have to place on record the necessary instructions, failing which the officer will be called.
Yes. This is the instruction.
My lord, I have the instruction, my lord.
Hmm.
Yes, my lord. This is the instruction, my lord.
You have given a copy to him?
No, my lord, I'm praying that, my lord, this should be brought on record by an affidavit. So when I there was no direction to file an affidavit on this, my lord, but this has to be brought on record, my lord, for an affidavit, my lord. That is-
Which department was earlier there?
WPT and BC was there. So now it has got bifurcated tribal affairs.
And prior to that?
No, my lord.
And when was WPT department formed?
22, my lord.
Prior to that, this is the repetition of 2024, 14.
21.
14.
Oh, my lord.
One repetition is of 2014.
14, my lord.
Huh?
That is item number.
I appear in item 6.
Item 6, my lord.
Who appears for 5? What is your case? Why both of matters are taken together?
Basically, broadly it pertains to delimitation only of the concept.
Welfare of tribe and backward classes department.
Yes, my lord. In number 5, I think my friend was supposed to make an implement of this.
No, this WPT is already there.
No.
This WPT has been trifurcated into 3. And you have been the original council. Department may change, there may be more commissioner secretaries coming, but Mr. Ardor remains everywhere in those 3 departments.
Not 3, my lord.
Maybe bifurcated, trifurcated, but his existence does not cease. Yeah.
So, my lord, basically, my lord, that instruction that I placed before.
In order to get the matters delayed, this government have trifurcated.
No, my lord.
Yes.
That is,
Then,
that is in
otherwise why?
No, my lord.
Why you are coming up with this instruction, that instruction?
No, my lord. Trifurcation was because of some other reason, my lord.
Very good.
In the line of that social justice and empowerment, that OBC, SC has to be taken out, my lord.
If a person A is held liable under anything in a civil proceeding, he may die. But his legal representatives, the problem will fall upon the legal representatives. And you are the legal representative. So you are, by virtue of the principles of law also, you are therefore to be there. And I will make every time you come up with new departments, tomorrow you may again bring the tribal department and change it into some other the tribal sub-classification department then. Yes, now what do you want to say with this?
My lord, I have to bring this on. I have to submission today, my lord. My lord, this I have to bring on record for an affidavit. Number 1, my lord. And my lord, I have received a letter, my lord. Actually, the government has, my lord, since the matter is very serious in nature, government has, my lord, engaged Mr. D. Majumdar, Additional Advocate General, to lead this case, my lord. And my lord, that the letter was, my lord, signed on 5th. That day, my lord, rained, my lord. So they could not deliver it. 6, my lord, I could not come, my lord, from Rukmini Gao. Everything was submerged. Yesterday, I received this letter, his engagement, my lord, in the case. It is still sealed, my lord.
Who? By government?
Mr. Government has sent it, my lord, to be delivered to Mr. D. Majumdar. And Mr. D. Majumdar is today, he is not here in town, my lord. So that is the my difficulty. So my prayer is, my lord.
And it is sealed. I can't open also.
No, I have a copy. The copy was marked to me, my lord. I have a my lord, that I am placing before your lordship. They have sent me a copy, my lord.
What? The government officials or the Mr. Additional Advocate General does not have a WhatsApp. This could have been forwarded. He doesn't have a phone which can be called up.
I understand, my lord.
Does he have to sign a wakalatnama?
No, nothing.
Isn't he the senior advocate? Then he
Exact-
can very well appear with you.
No, but my lord, usually, my lord, what happens, my lord, when a department engages specially, my lord, they send a request letter, my lord. That is what, my lord, this is what they have sent, my lord. So, my lord,
This could have been very well sent through WhatsApp or by email. He doesn't have email. You do everything sign, e-sign, digital sign, but then also you have to put it in that envelope and give it.
my lord,
Huh?
yeah. So, my lord,
Means when it comes to the court items, very good,
so,
great ingenious method. Yes, Mr. Chaudhary, have you looked into this? Some
I have not-
preamble amendment?
we have not.
Give it to him.
Thing is, in that case, let him put it on record, my lord. Otherwise, this simply remains a piece of paper.
Just have a look at it. The preamble of the Tiwa Autonomous Council Act provided for establishment of an Act provided for, because if it is unnecessary, why should I give time? Which have nothing to do with your matter?
my lord, my prayer would be, my lord will fix the matter Monday, Tuesday, any day, my lord. Suppose, my lord, Mr. D. Majumdar will appear, my lord, in this matter.
This is absolutely atrocious.
That is why my, that is,
It
that-
is that.
Totally in violation of the act. Absolutely in violation of the act.
And
They are-
that he will file it in an affidavit. Then he will come up and say, we have not challenged this, which means another writ petition.
Yes, that is exactly the whole idea.
Tomorrow you are going to give that submission. I have already brought in this. You have to challenge it. This is a decision. What?
They are doing delimitation on the basis of what people want. Lordship, kindly see the language. Majority of the organizations are parties are in favor of including
My
these
lord,
six
this is
constituents.
that
First paragraph, last sentence.
The committee believe that the majority of the organization and parties are in favor of including these 6 constituencies in the TAC area.
What
The
happens to
committee
the
observed that 2000 Iman was held smoothly without any law and voters turnout was so and so. The participants in this constituency expected the aspiration of the people to be a part of the TAC. A number of development schemes have been taken up since election were held in this constituency, which have committee therefore opined in favor of. Now, what is this committee?
my lord, is a committee of group of ministers and my lord.
Report record of the discussion of the cabinet subcommittee to recommend the inclusion of so and so. Is this conceived under the Delimitation Act?
no? This
My lord, the honorable division bench in a PIL, my lord, referred this to the chief secretary. Chief secretary to take a decision. There was no specific direction, my lord, regarding, my lord, delimitation. It was sent to the chief secretary. Chief secretary, my lord, in his own wisdom, has referred this to the cabinet subcommittee. Because, my lord, whenever these are very sensitive matters, my lord, that particular area, whenever we try to do something, my lord, there was law and order situation, firing, everything there. So, my lord, to have a consensus on everything, my lord, it was referred to a group of ministers, my lord, including government officials also, my lord. So that is why, my lord, this decision was taken in the cabinet subcommittee, my lord. And now the cabinet subcommittee has recommended this to be placed before the cabinet.
This will be done under what provision?
today,
Under what provision this delimitation is done?
delimitation, my lord, government is not supposed to delimitation, my lord.
There has to be a provision. It cannot fall out from the sky.
Section 48 of the Act.
Of the which act?
Tiwa Autonomous Council Act. It is annexed to the writ petition. It's at page 50 of the writ.
Where?
Page 51, section 48. Subsection 3, the government shall by order published in the official gazette determine the territorial limits of the constituencies into which the village council area or the council area shall be delimited for the purpose of election of members to the village council and the general council.
So their government, if it is the government, then obviously government can refer it to some committees. But this is being done. But what is the manner in which it is to be done?
The whole, the law says, the statute says that if those areas which have a 50% tribal population will be incorporated in this Tiwa Autonomous Council area. Our whole case is these 6 constituencies do not have that 50%, and in spite of that, they have deliberately, for political reasons, they have included it, and that is what was challenged.
Now, out here, what is the basis of you saying that it has to have this 50%?
50% on page 68. This act has undergone some amendments.
This is the
Satellite areas, your lordship will find.
Means area or areas consisting of non-contiguous cluster of villages predominantly inhabited by scheduled tribes population having 50% and above as a whole in the cluster.
Then core areas also 50%.
But this is scheduled tribes.
Scheduled tribes, not.
Although originally it was conceived of as a Tiwa council, but since then, with amendments, now it has become scheduled tribes. Wherever there are scheduled
But
tribes.
have they defined scheduled tribes only to be Tiwa?
No, it includes other.
So they.
Any tribe, my lord. Any.
But here they say 44 point, yeah. Oh no, they say there are majority. This, Mr. This thing does not answer your point if it is 50%. Because this exercise unnecessarily will begin another problem. Does it answer the 50% of the scheduled tribes?
Scheduled tribe, then it is to go for a census, my lord.
Huh?
We'll have to go for a house-to-house census. Suppose that 50% tribal population of that particular area, if you have to find, my lord, then only possibilities, my lord, we have to go for census, my lord. Head counts.
No, understood. That is one aspect which will go. But your basis of this record has no meaning then. Does this have any value? If this is not the consideration if it is taken.
My lord.
Don't file an affidavit. Don't file affidavit. We'll hear the advocate general, additional advocate general. And ask him not to say that I have been recently given a very fat beef. Okay?
My lord, when my lord is fixing the matter,
Huh?
I have to brief him also, my lord.
What?
So my lord is fixing the matter when, my lord.
When do you want it? Let us go by the convenience of your additional advocate general.
No, my lord.
Not by us. Let it be his convenience. Because again, you may have to send a letter by post. I hope you do by simple post.
No, my lord. Only
7 days, general clauses. Heard Mr. I. Chaudhary, the learned senior counsel, assisted by Mr. A.K. Borua and Mr. So. The counsel is representing the respondents, petitioners in both the writ petitions. Mr. Ardhol appears on behalf of the Tribal Affairs Department of the Government of Assam. Tribal Affairs Department planes of the Government of Assam. The Learned Counsel for the respondent department have placed before this court a minutes of the discussion of the cabinet subcommittee to recommend the inclusion / exclusion of 6 constituencies of the Tiwa Autonomous Council held on 25/7/2024. The said committee, after a threadbare discussion, opined in favor of inclusion of 6 constituencies of Kamrup Metro District, namely 26 Dimoria constituency, 32 Digoru constituency, 33 Khetri constituency, 34 Hunapur constituency, 35 Ampri constituency, and 36 Hong Ari constituency in the Tiwa Autonomous Council. The learned senior counsel appearing on behalf of the petitioner submitted that the manner in which the recommendation has been made prima facie appears to be not in consonance with the Tiwa Autonomous Council Act 1995, taking into account that in terms with the amendment so carried out by the Tiwa Autonomous Council Amendment Act 2005, the basis on which it is to be done is to be taken as predominantly inhabited by scheduled tribe population having 50% and above as a whole in the cluster, and not necessarily in the individual villages. However, the learned senior counsel pointing out the basis of making the recommendation submitted that in the instant case, the subcommittee have believed that the majority of the organization and parties are in favor of including these 6 constituencies. This, on the face of it, was not in the terms with the mandate of the Tiwa Autonomous Council Act 1995. Mr. Ardhor, learned counsel appearing on behalf of the respondent department submitted that the government of Assam have that his department have this department taking into account the importance of the matter have engaged the services of the additional advocate general Mr. D. Mojumdar, and as such he would like some time in view of his absence to list the matter when 7 days General Clauses Act when.
Just I will make a phone call, my lord, to Mr. D. Mojumdar and get the date.
No, he doesn't have a phone. Obviously, he doesn't have a phone. Otherwise, the people would have called kindly appear. Huh?
His junior is there with him, my lord. I can call.
Testing.
On
We have, yes, Mr. Advocate, he's more busy person than him. Tell me, when?
On 20th.
20, no, 20, lots of matters. I've got other matters. 22nd, how many matters did I pick? Lots.
That case, 27th.
27th of August. 27th of August, 2024. Full stop. This court also duly takes note of that the minutes of the said meeting, reference of which have been the minutes as well as the recommendation of the said meeting, the mention of which have been made in the order have also been handed over to Mr. A.K. Burwa, the learned counsel appearing on behalf of the petitioner.
But you may perhaps like to keep it part of.
No, enough. Yes, what is this?
Petitioner was running a grocery shop in the weekly market for last 25 years. As per an XFC, notice was issued by the 7th Town Committee that they will reconstruct it and the rooms will be allotted in the daily market and the weekly market. Thereafter, the old room in the weekly market comprising of 6 rooms were dismantled, sorry, 4 rooms were dismantled and it was newly constructed. After that, 3 of the earlier tenants was given the rooms and another new tenant, except the petitioner in the weekly market. After that, we filed agreed by the order that we filed a representation, and we have initially this honorable court has given a stay order. But despite the order that on 13 to 15, they have allotted the rooms to the new private respondents. And they have said that as per Annexure C.
What are you challenging, Mr. Council? What are you challenging?
The allotment of the Annexure C and FNG.
Huh?
Annexure C and Annexure FNG.
You see.
Page 28 and page 33 and 34.
Application is prescribed for allotment of rooms of newly constructed RCC complex at daily market and weekly market, Warner on monthly basis. Invited from interested buyer. Now, why you are challenging this?
Because I legitimately expected that I will get this allotment without, because I was doing the business there for last 25 years. Earlier, all except me, other tenants were given the rooms.
How?
We have given this application.
No. Where is your agreement that they will give you? Where is your agreement that they will give it to you if you hand over the possession?
Because there was a legitimate expectation.
Oh, legitimate expectation has to be based on some right. Some right has to flow on the basis of a promise or estoppel, something to that effect. Where is the promise?
In Annexure C, there was no number of rooms were mentioned in Annexure C. There is no room number. The petitioner thought that as requested by them, said they have said that they will give the rooms.
Then
I participate. I given the application in Annexure D. All it is, I deposited the money of 60,000 rupees, and
you submitted your application.
Yes.
And deposited a security deposit.
Yes.
Then
all this is complied, but without any reason. Giving any reason, I was not selected.
Huh?
I was not selected.
are hereby informing to attend the Udalguri so and so. So you were not selected.
Yes, sir.
So it was FNG are the people who have been selected.
Yes. On 13.
What is the name of the petitioner? Ponidor Sharma.
On 13.
What is this? At Annexure G, the application of the following are paying for allotment of the constructed in monthly were not considered to be allotment by the so and so and held on demand. Therefore, the following after hereby invited to collect the security deposit. So you were asked to take back the money.
After that, Annexure A is page 36. I have given representation.
Then
I agree by this order. I have filed this petition on 13 to 15. The court has given interim order not to allot the rooms, but on 18 to 15, they have allotted rooms to the petitioner in spite of receiving the
okay, that I am not bothered. I am concerned now with.
And
I am only concerned it as to how they have make the decision.
And what has happened? The respondent number 3 and 4, the Udalguri Town Committee and the private respondent has jointly filed the affidavit. They have contributed with the solicitor. And what is in the affidavit? They have taken.
No. What is the basis on which the possession was held?
Yes.
Who is appearing for the government? This Udalguri Municipal Board?
I am appearing.
Yes, tell me, what is the basis of arriving at the decision?
I told your lordship the C page, Annexure C at page 28, your lordship may
kindly see 7 number, my lord.
Huh?
As per agreement,
Page
page 28,
of,
main petition, my lord, is the writ petition
yes.
as well. 7 number, my lord, para 7.
No lessee tenant will be allowed to transfer or lease once allotted to other party.
Yes.
Then,
In the meantime, he has subletted the said room which was allotted to in the year 91, 92 for 1 year only. Then he, as per the first agreement, my lord.
Hmm.
And then he has owned his grocery shop nearby the new building constructed, my lord.
he has a grocery shop.
Grocery shop, my lord.
Where is your affidavit?
Yes, my lord. I have already mentioned in my affidavit at page.
It was filed on 10/4/15.
Yes. Yes, it was a. Para 4, my lord. That in regard to the statements in paragraph 2 and 3, the deponent denies. Further back to state that the petitioner was allotted a room number 11 of measuring 12 by 16 in the year 91 for a period of 1 year only, with effect from 1901 to 30 1992 at monthly rent rupees 200 rupees 100 only, by executing an agreement between the Odalguri Town Committee and the writ petitioner as the proceedings of the meeting dated 10/5/91 to not in the year 1989 as he claimed, my lord, measuring 12 by 18 as claimed by the writ petitioner. A copy of the said agreement was dated 31/12/1991 is enclosed herewith, which is self-explanatory for ready reference. Further, it is to be stated that the writ petitioner never used the said room, the running shop business himself in the said room, rather subletted the said room to another person, namely Bhaskar Das, private restaurant number 10 of the instant petition from beginning on rent basis at rupees 300, whereas the actually was 200, but he getting the benefit 100 getting sorry, per month to the writ petitioner, and the petitioners used to pay an amount of rupees 200 till the date of allotment of new RCC.
How many rooms were there?
There are numbers of rooms, my lord. As per it is the central government's scheme, my lord.
4 rooms were there and
No.
4 rooms were there earlier. After reconstruction, it was 6.
So they gave it to
my lord.
6, 7, 8, 9, 10, and 11.
And
3 other tenants were given. And then
How many rooms? There are only from 6 to 11.
yes, 6 rooms. Your lordship, 6 rooms, but 3 are other tenants. That respondent number.
No, 6 plus another, how many rooms? 9 rooms.
Earlier it was 4 rooms. Total it is 6 rooms. Earlier 3 tenants were given, and new 3 total 6 rooms. 3 plus 3. 6.
Now, who is
7,
appearing for the private respondents?
private respondents, actually, one, my junior was also appeared, but he submitted.
No, now, Mr. Counsel, let me ask you one thing. This notice was issued at page 28, annexure C. This notice was issued stating that no lessee tenant will be allowed to transfer or lease once allotted to the other party.
Yes, sir.
This will only happen after you grant the lease.
Oh, my lord. Earlier, as per agreement, this agreement was only for 1 year, my lord. And as per, it is a central government the scheme for developing the Northeast marketing system.
No, no, earlier agreement, did it say that if you sublet it to somebody else, for future you would never be granted an allotment?
No, my lord.
Then we set aside this as regards the 3 new tenants. Remaining, it's okay. Then you choose amongst
lord.
them to consider the case of petition. Matter over there. What is there?
My lord, yes, my lord, there is a, other than,
If that is the reason why, the other reasons are not there.
yes, my lord.
What other reasons?
Other than,
Once he is being allotted, he cannot sublet.
yes,
Fantastic.
yes, my lord.
But he has not been allotted. This is your application.
No, my lord, earlier LOT, my lord.
Where did you say earlier allottees would not be allowed once allotted earlier having done? Where is it mentioned?
My lord, he has already one grocery shop nearby the new building, newly construction, my lord. So he never used the earlier.
And when
allotted
were these people handed over?
On 13 to 15, the order was passed. On 19 to 18 to 15, I get a certified copy of the order, the receipt of the town committee. On 19 to, they have handed over, 19 to. 19 to 15.
Agreement entered into with 6 to, yeah?
On 19 to 15.
And there was a stay.
Here's the stake.
No, my
Heard
lord.
Mr. S.R. Gogoi, the
My
learned
lord,
counsel
please,
appearing on
my-
behalf of the petitioner. No, no, nothing doing. We set aside all these allotments. And Mr. Your name?
B. Ramsey.
Hmm?
B. Ramsey.
P. Ramsari appears on behalf of the Udalguri Town
Response
Committee.
number 1,
Udalguri Town Committee,
3 and 4.
3 and 4. Full stop. Who appears? 1 and 5, so and so appears, and Mr. and BTC, so and so appears for the BTC. Who appears for respond number 6 to 11?
Earlier, my junior appeared.
None appears on behalf of the respondent number 6 to 11 on call. Full stop.
My lord, may I submit
petition-
one report?
No, no, nothing doing. When there is an order passed, then after on affidavit, you admit that there is a violation. Nothing more than
Yes,
that.
yes, I mentioned in my affidavit, there is a
Yes,
violation. Yes,
when the
my lord.
order is passed on 13/2/2015,
But it was received only on the 18th, my lord.
then why did you hand over on 19th? At this stage, an interim order according till the next day, no allotment shall be made in respect to the year or the year
19, my
in
lord.
case allotments have not been made. Now, this is the order. You got it on 18th.
No, my lord,
18 to.
19, my lord.
You got when?
19.
19.
Yes.
And you say, and yeah, so and so, and those who were allotted the rooms in the year, they were handed over the possession of the room by executing papers on 19/2, along with the keys on 1st of year. This is absolutely in violation of this court's order. None appears for the the case of the petitioner herein is that the petitioner was an earlier tenant of the under the Udalguri Town Committee in respect to a shopping complex which consisted of 3 rooms. 3 rooms.
And it was 4 rooms.
4 rooms. Full stop. Subsequently, in order to reconstruct the premises and make it better, the Udalguri Town Committee took over the possession of the said room from the petitioner and thereupon constructed a new RCC building having 6 rooms. Pursuant thereto, a notice was issued on 5/5/2014, whereby applications were invited for allotment of the rooms of the newly constructed RCC shopping complex at Daily Market Ward number 3 and the Weekly Market Ward number 5 on monthly rental basis from the interested traders of like businessmen on various terms and conditions. The petitioner accordingly applied by depositing a security deposit, which was duly acknowledged. However, to the shock and surprise of the petitioner's application was rejected.
No, my lord, the petitioner did not claim any refund of security money.
Was rejected, and accordingly, a notice was issued on 8th of January 2015, asking the petitioner to take refund of the security deposits so made. The petitioner thereupon submitted a representation on 22nd of January 2015. However, as the same fell in deaf ears, the petitioner approached this court by filing a writ petition, the present writ petition. It is very pertinent to mention that on 13/2/2015, when the matter came up before this court, taking into account the facts, not only issued notice, but also directed that till the next date, no allotment shall be made in respect of the RCC shopping complex at Wednesday weekly market in case allotment have not been made till date. The notice was made returnable on 25/3/2015. Full stop. The petitioner, it is the case of the petitioner that on 18/12/2015, 18/2, that is 13/2, na? On 18/2/2015, the said certified copy was served upon the
3 and 4.
respondent numbers 3 and 4. However, most surprisingly, on 19/2/2015, the respondent numbers 3 and 4 entered into agreements with the respondent number 6 to 11, as well as also handed over the lock and keys on 1st of March 2015. This aspect of the matter is clearly admitted by the respondent numbers 3 and 4 in the affidavit filed by the chairman, Udalguri Town Committee, on 22nd of April 2015, and which is clearly seen from paragraph number 5. Therefore, on the face of it, the action so taken by the respondent number 3 and 4 was in gross violation to the order passed by this court. The consequence, it is no longer res integra that when an authority takes any action which is in gross violation of the court order of this court, it would amount to the said order would be non-est. Under such circumstances, the entering into any agreements with the respondent number 6 to 11 and handing over the locks and keys on 6 to 11 on 9/2/2015 and handing over the locks and keys with effect from 1st of March 2015 clearly shows would not create any right in favor of the said private respondent number 6 to 11, as the same was at the teeth of the order passed by this court. Be it as it may, this court have also taken note of the reason why the petitioner's application has been rejected. It is seen that the rejection of the petitioner's application is on the ground that in the notice dated 5th of May 2014, whereby applications were invited, there was a clause, being clause number 7, wherein it was stipulated that no lease/tenant would be allowed, lessee/tenant would be allowed to transfer or lease once allotted to the other party. This clause was incorporated. This clause was taken into consideration to reject the application of the petitioner on the ground that the petitioner in the year 1991 had subleased his allotted shop. In the opinion of this court, this clause in the notice would have only been applicable in respect to an allotment so made in pursuance to the said notice, and not in respect of any in respect of any other in respect of a infirmity which had existed much prior to the issuance of the notice. Under such circumstances, the reason on which the petitioner's application was rejected on the face of it amounts to a malice in law, taking into account that a consideration, a circumstance has taken a circumstance has been taken into a certain taking into consideration that an aspect has been taken into consideration which could not have been taken into consideration, and as such, this court is of the opinion that this is a fit case for exercise of the jurisdiction under Article 2 to 6 of the Constitution. Accordingly, this court holds that the grant of holds that the rejection of the petitioner's application on the grounds so assigned in the affidavit in opposition amounts to suffers from malice in law and is illegal and arbitrary, and accordingly the said rejection is set aside. Full stop. This court in the previous segments of the instant order have also taken note of that no right has flowed upon the respondent number 6 to 11 on the basis of handing over the possession as well as entering into certain agreements, taking into account that the said exercise was carried out in complete violation to the orders passed by this court. Accordingly, this court directs the respondent authorities to carry out a fresh exercise for selection of the fresh exercise of selection for allotment of the rooms in the newly constructed RCC shopping complex at the Daily Market Ward number 3, at the Weekly Market Ward number 5, in accordance with law. Full stop. The said exercise be completed within a period of 3 months from the date of the instant order. Full stop. Basing on the said exercise, the respondent authorities shall take due action against with above the instant petition stands disposed. These matters should have been disposed of long time. Yeah, how much time does it take this thing?
I am not taking the time, my lord.
Huh?
I am not taking, I did not.
No, not you. It's not that. It is because of the fault of us.
Just
This matter could have been finished up on any day
Yes,
in
yes,
2015. This is not such a big matter. It's not a small matter. Isn't that Mr. Chaudhary?
Lord,
Mr. Chaudhary, what do you say? These type of matters,
yes,
it shouldn't have been at all.
2015, Eight to. Malad, in item number 8, I am the petitioner, and in other, I am the respondent. Now, what has happened, I'll give a small brief background, my lord.
How many cases are there? One.
Four cases.
What is the matter about?
What had happened, my lord, in this social area, a 30 big of land was allotted by the government on payment of premium to a particular society called Purbanchal Griha Nirman Unnayan Committee. Now, what had happened, my lord, after allotment of the land, this entire area was included within the schedule of that 2006 Act. As a result, my lord, we could not make any construction. In fact, that was the time when this society and its members were thinking of, my lord, getting permission from the authority for undertaking construction. Basically, it's a housing cooperative, my lord, where the members would have benefited. Now, we filed the writ petition, first writ petition, which I filed for the petitioner in the year 18, where our prayer amongst others was that since the land, adjoining lands are not included within the schedule of the act, therefore there is no justification to, include this land in the schedule of the act. Because once it is included in the schedule, it's a scrap of paper and we can't make any construction. Anyway, my lord, the matter continued. Therefore, then eventually a time came when we informed this honorable court that the government, if government doesn't allow us construction, then government should acquire this land.
Yes, yes, that is why I passed an order on 8/9/2023.
Yes.
And it has come almost after 1 year.
Yes.
The government was to.
No, my lord, the government has now issued notice on this new act. They have in fact earmarked the money, everything is done. Now, my lord, there are some disputes has arisen within the members regarding apportionment of the compensation amount.
So let the district judge decide.
Exactly, that's the issue. Because under the act,
This court decide.
under the act, it is that authority. Section 27,
Under which act?
new act, my lord,
That will be 64.
authority, yes,
64.
yes,
It will be the district judge.
yes.
Where this aspect has to be decided, nobody else.
And in fact, government has kept the money in a particular account. Eventually, now some of the members
The
have gone to-
problem which will arise is the people will be losing interest.
Exactly.
Because the moment they deposit out there,
Hmm.
the interest is finished.
In fact, my lord, government, in fact, in one of the affidavit filed by one of the contesting party, they have annexed an order of the government whereby the money has been kept. That once these
Now,
disputes
what
are
remains in these matters now?
nothing, my lord. Our humble submission is, my lord, the now matters should be referred to their authority regarding apportionment of
Your matter is 74757.
But in the other matters, I am the, my lord, respondent. As a
Which matter
society.
you are?
Yes. In fact, my lord, 7457 has become infructuous. Because in our prayer was, has been virtually.
It has already been done.
No, done in the sense, my lord, alternatively, we prayed that the land should be acquired.
So
Government
they
is
are
acquired.
acquired. Now, have they passed the award?
Yes, everything is
What has
done.
been passed?
My lord, Kuntu file, no?
Show me the award.
Yes.
359.
If item number 2 कौन है? Non-AMR 2 कौन है?
Item number is.
It was.
Item number 11. Item
If
number
the lordship kindly takes item number 11, where one of the petitioner is filed.
File suit.
Like two suits pending, filed by the. Filed suit against the site divider, and there is an injunction order also. That has not been.
No. So now, as of now, the fight is between the members.
Yes, within the members.
Society. Members of the society.
No, there cannot be a society without the members.
Yes, but.
Can there be? A society composes of the members.
Yes.
So under such circumstances, there cannot be a fight between the society and the member. It has to be a fight between the members
Some
and
members
some
and the
controlling the
society represented by some members.
Executive body of the.
It may not, this is the question of apportionment.
Exactly, boils down to that.
How much each will be entitled to. So why it should, but otherwise the money is to be paid to.
In terms of the landowner. Yes.
So under such circumstances, there is no quarrel with Purbanchal Griha Nirman Committee with others. Who are you?
Because there is a dispute.
There is sort of one agreement where, see, one of the petition, the second petition, my lord, I am the builder to whom the land was, or I was required to develop the land with my expenses. There is an agreement with me where I am put in possession of the land.
So that is your difference case. No. There you don't have any right. You don't have, these matters do not come before the authority. this is to be done before a suit.
Yes.
The reason why I'm saying is the money, it will only come if they have a right which is independent of your right. Is it your right independent of them? No.
No.
Your right springs from them.
Exactly.
So you say that you are entitled to a part of it because you have also right out there.
No, no,
But-
we are not disputing that as a society.
What I was trying to say is streets are disposed of. It's an observation that interstate rights are not being
Huh?
decided in interstate rights of the parties of any of the parties are not being decided or.
Of course not.
That is the.
I'm not going to decide
never-
anything. No, I'm not going to
In fact,
decide.
the government has already passed an
No,
order.
no, therefore, it will not come under 64.
Yes.
Because 64 will be if they have a right along with you having a conflicting right. Then only it will 64 will come how much you are entitled or how much you are entitled. But the money here, there's no denying that the money is his. But from there, you need you want each so all of you have a share. So it is a fight that once the money goes to them, how much you will get.
Exactly. In fact, my lord, the society is not disputing the claim of anybody. So lordship should kindly have page 359, my lord,
Of which
of that
petition?
item number 11.
7457.
Yes,
No, 7355.
7355. Please have, my lord, page 359. This is a communication by my lord, Additional Secretary, Department of Housing and Urban Affairs, to the District Commissioner Kambu.
350,
9.
59, 343 I have.
I think it was called for. No?
Yes.
So the
Oh,
additional
some-
affidavit
yes,
was-
yes, new one, yes.
If your lordship will kindly have page 359.
Yes.
With reference to the subject and letter cited above, I am directed to inform you that land measuring 30 biga covered by Dag number at so and so, belonging to Purvanchal Griha Nirman Unnayan Committee, is under prejudice in Nizze case number so and so. In view of above, you are requested to keep the money in civil deposit account at the time of release of fund against acquisition of the above mentioned land till settlement of it. So that way, my lord, everybody's interest is protected.
No, but why the money is being kept in a civil deposit account?
No, what I'm saying is,
It
my
may
lord,
be
as
in
of
a-
date, it has not been disbursed to even to us also.
No, understood.
Ah.
It may be in an escrow account, but whether interest
Actually, it
will
should have been
accrue,
an escrow account.
whether interest will accrue on this.
No. Nothing.
Therefore, it will remain stagnant.
Stagnant.
So unless, therefore, don't you think that this court should clarify to this
Yes, yes.
respect?
Yes,
And
yes.
direct them that the civil court may pass appropriate order, don't you think?
One of the petitioner has prayed before the additional secretary.
Ah.
No, এখন move file গুলা কি হবে?
Because there won't be any interest here. You are losing on interest.
But there
Because
are
otherwise the interest is 9%.
এখন কি হবে?
The interest we are losing. And this matter may go a long time.
Item number 11, into 11 even though.
এইটো কি?
A2 here.
Now, my lord, if your lordship would kindly have the act for a moment,
Yes.
13 Act.
Hmm.
If your lordship would kindly have section 3R.
Right to fact.
Provided no push at all.
E?
My lord, 3R, my lord.
Yes.
Landowner includes any person whose name is recorded as owner of the land or building or part thereof in the records of the authority concerned. So, my lord, we have given the patta, jamabandi, everything. So, land is in the name of my lord Purvanchal. So, money has to be deposited in the account of the Purvanchal. Now, based on other my lord clarifications or whatever it is, I mean, disbursal would take place.
No, the amount of compensation.
But I'll kindly draw your lordship's attention to only two provision, my lord. Please come to page section 27 for a moment. The collector, having determined the market value of the land to be acquired, shall calculate the total amount of compensation to be paid to the landowner. Then my lord will kindly come to section 51. The appropriate government shall, for the purpose of providing.
No, kindly come to 37.
Yes. Award of collector when to be final. Award shall be filed in the collector's office and shall, except as hereinafter provided, the final and conclusive evidence as between the collector and the persons interested, whether they have been respectively appeared before the collector or not, of the true area and market value of the land and the assets at the solace. Yes, correct. Then my lord will kindly come to
Then 38. The collector shall take possession of the land after ensuring the full payment of compensation as well rehabilitation, resettlement
Yes.
as paid
Ah.
or tendered to the entitled persons
Yes,
within a period of 3 months from the rate of compensation.
correct.
So therefore, don't you think section 2X will come into the picture?
1 second, my lord. 3x.
3X.
All person claiming an interest in to be made on account of the solutions. Yes. The same principle as in the old act. Yes. Now the question is, therefore, it appears there is some dispute as to who would receive how
Now,
much.
Kindly come to 64.
Yes. I think, my lord, the more, because I think 76 would come, my lord.
If kindly come to 64.
Yes.
What is the scope of the
Any
reference?
person interested who has not accepted the award made by written application collector required that the matter may be referred by the collector to the determination of authority. Precisely that is what we are saying.
Whether his objection to the measurement of the land,
Huh.
the amount of the compensation,
Yes.
the person to whom it is payable,
Yes.
the right of the rehabilitation under so and so.
Because
So under such
64 is who a person interested, and my lord 76 is regarding apportionment. In any case, matter has to go. When the amount of compensation has been settled, if any dispute arises as to apportionment of the same or any part thereof, or as to the person to whom the same or part is payable, the collector may refer such disputes to the authority.
So under such circumstances, if did be so, how is the civil court maintainable?
Exactly. And civil court has no jurisdiction.
Award has not been passed.
Award has been passed?
Award is not passed. Only estimate. Estimate has been.
Estimate has been requiring the award.
Huh?
Estimate has been.
So where is the award?
There is no
We are
award.
going into something more.
Deposited that money.
Huh?
Requiring department has yet to.
Then you are saying the amount is to be kept in the civil court somewhere, some deposit here, but you are not yet final. That document which you are bringing today by way of an affidavit, whoever has filed it, this document says, in view of the you requested to keep the account in the civil deposit account. Right? What is this?
Communication of urban development.
But first of all, you have to give the money to the deputy commissioner. without giving the money to the deputy commissioner, you are saying the deposit in some account.
I think my lord, money has been deposited. I think my learned friend should have the instruction. Even our info, money has been deposited.
Otherwise,
Yesterday also concern.
We'll have it on 19th. Get your instruction whether the money has been deposited and the award has been passed. Well, what is the problem in passing the award?
Position is not done, my lord.
How does it relevant? Why you're not passing the award?
Oh.
You pass your award, then only the deposit happen. You see, kindly appreciate one thing. I don't understand why the state government have not been able to understand this very basic concept. The delay in passing the award, there's an interest of 12% in terms of section 33. So who is going to pay?
State.
You. Deputy Commissioner. What is his or her name? No. Deputy Commissioner has to pass. Pay. Who is his or her name?
Ultimately stated to pay.
Right now, Mr. Sattavan is.
Yes. He has to pay from his pocket. No, obviously. So under such circumstances, yes, because you are not understanding this is required to be passed. If you pass it, then the interest should at best be 9%. Only appreciate from the 12%. You are still reducing 3%. This amount is not a small amount. How much is that?
162 crore.
Then 162 crores. How much it will be the interest? The difference of the 3% is also very relevant.
Even by today's context.
And deposit it out there. It has been submitted by Ms. Embormon, the Learned Counsel, appearing on behalf of the state respondent state, that it is not that she's not aware as to whether the award has been passed in the instant proceeding. In the LA case number. LA case number what?
35 of 20.
35/2023. She further submitted, she would also like to obtain instruction as to whether the amount has been placed before the district commissioner, Kamrup Metropolitan District, for payment of, so that the amount could be disbursed to the beneficiaries. List the matter again on 19th of August 2020. Is the matter to finish? Hello, Arnold.